Everybody. I'd like to welcome you to the special meeting of the Bethlehem Zoning Hearing Board. My name is Jim Shantz, and I will be serving as the acting chair for tonight's meeting. Other members of the board from my left are Carol Ritter. Carol is an alternate with the board. She will be listening to testimony, but she will not be a voting member of the board. And I'll explain at the end of why that's such the case. Terry Novotnik, Linda Shea Gardner. Our solicitor for the evening is Eric Schock. Craig Pfeiffer is a zoning officer for the city of Bethlehem. And our our stenographer tonight is Jean Genova. As we have two permanent members of the board, seated members of the board who cannot be attending this meeting this evening. Pete Schneck and our chairman, our normal chairman, Bill Fitzpatrick. Since we are having four members would create a 2-2 tie and possibly delay the hearing. Since three members do constitute as a quorum of the board, we have decided to go ahead and go with three members tonight, as opposed to putting everybody in the awkward situation of going with the fourth member, continuing it, or having to continue it until there are five members present to the board.
Yeah, and if I could just point out, if you look at the MPC, and council, feel free to disagree with me, but in an instance where we have a quorum, it says the chairman may appoint an alternate if he so chooses. There's no mandate that he do so. So we will sit with a three-member board because that constitutes a quorum, and we're not obligated to appoint an alternate.
And in the case that one of the members of the board would not be able to be present for another meeting, Ms. Ritter, having sat in, hearing the testimony, but not voting, could take that third member's place at that time and then constitute a quorum of the board.
Or we will find a date that the three members hearing it tonight will be available. That will be our preference, to find a date when the three sitting voting members, Mr. Shantz, Mr. Novotnik, and Mrs. Shea Gardner will be available for a hearing if there's one after this evening. Okay. Make sense to everybody? Any questions?
Yeah, may I respond?
Sure.
Attorney Tim Stevens for the appellants. I just need clarification with respect to the alternate service. So in the event that one of the board members cannot serve, Ms. Ritter would stand in and be a voting member at that point. Is that what?
That is an option that is an option we could exercise, or we could continue until the other two members or the other three members are all available to continue it to that night.
And our preference would be to do that, but there is the potential for having the alternate step in, which is why we're having her sit there. Look, hopefully we will avoid that.
Yeah, fair enough. I just want to place on the record, in the event that Ms. Ritter becomes a voting member, the appellants do have an issue with her sitting and becoming a voting member, in that there's concerns in that Ms. Ritter apparently had political signs on the subject property at 2 West Market Street, and I believe it was more than one. There were several signs, and I've seen pictures of them. I have Mr. Haynes here. He could put in testimony that he visually saw the signs at the subject 2 West Market Street property. It would be our position that's enough bias, enough interest, enough conflict of interest that we would respectfully request that Ms. Ritter recuse herself from being a voting member in the event that should transpire.
Okay, we'll address it if it comes up, right?
Yes. When we hope that we're able to continue and complete, ideally we'd love to complete the hearing tonight. Ideally, if that can't be the situation, we'll work our best to hold it on. And if we have to continue it to a second evening, we will continue it that second evening. We will continue it to a point where all three of the voting members that are currently on the board are able to vote on the matter.
But you've otherwise preserved the objection, but there's no sense in my mind to deal with it now. Good?
Fair enough. Yes.
Very good. Perfect.
Since there's only one appeal tonight, we'll have the zoning officer for the city of Bethlehem make that announcement then. Once again, our court stenographer is Jean Genova. She's going to be swearing everybody in, along with anybody else who may wish to question or testify at tonight's hearing. Your testimony will be considered as sworn testimony and will be included as part of the formal proceedings. People in the audience wishing to question question testimony or introduce testimony will have a chance to do so. First questioning of testimony will be introduced by the parties, will be afforded to the audience following each witnesses for the applicant. I think tonight, procedurally, Attorney Stevens would present his situation. We will then let the city solicitor then question Attorney Stevens's witness, Attorney Deschler, followed by Attorney Preston, followed by the board, then followed by the audience. If that's the procedure, if that's the order that we can go with at that point. Only following the completion of testimony by the party making the appeal will testimony be accepted from members of the audience. We ask that members of the audience avoid repetitive questions or testimony. Anyone aggrieved by this decision can appeal the decision to the Northampton County Court of Common Pleas within 30 days of the issuance of the written appeal, of the written decision as written by Attorney Schock. We also have, at this point, I would like Mr. Pfeiffer to please read the application tonight as it was posted.
And if I may, Mr. Chairman, just a few housekeeping items as it pertains to the live stream. For the purpose of that live stream, it is important that anybody that does ask any questions or provides any testimony to speak directly into a microphone. There are several microphones at the podium. There's one up here to my right as well. Also, the live stream cannot be paused. So if there's an executive session where the board leaves, the microphones stay on, the camera stays on, and whatever is recorded becomes part of that record. With that, I will go ahead and read the appeal. This is the appeal of Beal Fowler, Robert Romero, Martin Romero, Barbara Diamond, Steve Diamond, and Bruce Haynes for a validity challenge to appeal the adoption and enactment of Bill number 46-2018, ordinance number 2018-40, section 1304.04, reuse of a corner commercial uses allowed in the RT high density residential and RG medium density residential districts, specific to paragraphs 1 through 4, as they relate to 2 West Market Street. The full text of the ordinance may be reviewed by members of the public at the Bethlehem City Hall Department of Community and Economic Development, Bureau of Planning and Zoning, located at 10 East Church Street, Bethlehem, Pennsylvania, 18018, sections 1304B, and all associated variances, special exceptions, and interpretations apply. This record lot is 8,625 square feet and is located in the RT High Density Residential Zoning District.
Thank you, Mr. Pfeiffer. For the record, do you know when or if the property was posted, Mr. Pfeiffer?
Certainly. We did prepare a placard and advised the owner of the subject property that it was available for them to pick up. However, I did receive an email from their attorney indicating that they were not going to pick up that placard nor post it on the subject property.
Okay.
Thank you.
So let's address that issue first. We keep referring to the subject property. I think my understanding from counsel for the property owner, whether it's the subject property or not, is that the use of the subject properties, what's the issue here? Mr. Preston, you want to address that? Because
Sure. My client has no matters pending before the zoning hearing board. We filed no applications. We've made no submissions, and we don't intend to post our property because we have nothing really in front of the zoning hearing board. We did have a matter in front of the zoning hearing board. That was our special exception request. The property was posted, and the objectors had the opportunity to appeal that, and they did. That's on appeal. So that matter is taken care of. The matter before the board here tonight is a challenge to a zoning ordinance of the city of Bethlehem. That's what's in front of the board here this evening. I suppose if they want to post the property, they could post City Hall. But this ordinance affects multiple properties throughout the city. And in fact, this notice provision is interesting because it sort of goes to the essence of the case. And that is this an ordinance that affects a single property, or is it an ordinance of general applicability? What this notice requirement sort of does is put the rabbit in the hat and says that it's our property is the only property that's affected. We disagree with that. We think that this ordinance, this challenge before the zoning hearing board, is a challenge to the zoning ordinance of the city of Bethlehem. and we don't believe that we need to post our property because we don't have any matters in front of the board.
Thank you.
I believe the impetus on the part of Mr. Pfeiffer to invite the Mr. Preston's client to pick up the posting for his property was at my behest, not directly, but I thought that in reviewing the MPC section 908, while it wasn't clear from the city's standpoint, it would seem that out of an abundance of caution, so to speak, we could make a posting available for that property. I spoke with Mr. Preston today about this, and I understand his position. Again, the city's not really taking a position on that. We thought that, again, out of an abundance of caution, it might be something that we could do. I don't think that it's an impediment to our proceedings tonight. I think I would actually accept Mr. Preston's position that what we're here tonight on is not an issue that affects particularly this subject property, though that proceeding is really now in common pleas court on the appeal from the grant of the special exception. So again, the city has no problem with proceeding tonight. We don't think the decision to decline posting the property is any kind of procedural infirmity.
I guess the one thing I would suggest is I'm not sure how we can make someone who's not the property owner, because normally I look at this, Mr. Stevens, as someone comes in and says to the city, I want to ask you for some relief to the zoning board, right? And I think that creates the authorization for I would think even the city would have the right to go out and post the property if I came in and asked for a variance. I don't know if we can force them to do that. So, and if we can't force someone to post it, because I agree with Mr. Deschler, I rather would have just maybe done it, because if it's wrong, who cares from my perspective? If it's right, well, we did it right. If we can't force them, then I don't know how that should matter. That could stop your appeal, because you could stop anyone's appeal by just not agreeing to post the property that arguably might be affected by the challenge, right?
As far as the appellants are concerned, to the extent that there is any obligation either on the property owner to post for today's proceeding or the city to post any affected properties and make sure they have notice of this proceeding, we certainly reserve the right to object that there's improper notice for today's proceeding. I just think it's unclear amongst the parties as far as what that notice obligation is, but we're certainly reserving the right to raise that objection and amend our appeal to the extent that that hasn't occurred for tonight's proceeding.
Yeah, I mean, I'm comfortable to say, let's go ahead. And I mean, how else are we going to do this? Because I don't know that the city can go out and post the product for, you start picking corners to just post, right?
The reality, it goes to the very core, and I think Mr. Preston has touched on that. I disagree with his view of the amendment that it affects
Exactly.
multiple properties. It only affects one property, and therefore we certainly disagree on
Someone
that.
would need to tell the zoning officer exactly what we're doing, and we're not there, right? I mean, the 2 West Market obviously was part of a separate one that did utilize this ordinance, but that's the other appeal. So if everybody's comfortable, I would say we go ahead, and I don't know that is going to prejudice anybody's rights.
I agree. Again, my suggestion was out of an abundance of caution.
Sure.
But I don't think there's any procedural infirmity here.
Yeah, I got that. Okay. So that one's good. I think what we need to do now is I sent a letter out saying we would just keep going through these other procedural matters before we got into any testimony. So let's move on to the next one, which I know Mr. Stevens has a witness here related to one of them. So let's go on to the transcript question, right?
Yes.
Okay. So just explain what you're asking. And I know Mr. Deschler put in an objection. And then Mr. Preston, you're welcome to add to that. The more the merrier on all of these. So, but yeah, Mr. Stevens, just go through, because I'd like to do these all on the record, because I think it's the easiest thing rather than us having exchange paper outside of the hearing.
Okay. I've pre-marked Exhibit 24, which both the applicant's attorney has, as well as the city solicitor. It's all in a binder. I don't know if you want me to hand the binder up now, and if you would just turn to Exhibit 24, then you'll have copies of the communication on the subpoena issue,
Okay,
as well as the
yeah.
transcripts.
Yeah.
So why don't we do that?
That's
and then
that.
everyone will
So,
be-
so this is the letter that you've already sent to the other council and myself, correct? Okay. Do you have any objection to that, the letter that he sent relating to this?
It's Exhibit 24.
When you get through the file, right? In this packet, okay.
Thank you.
Yeah, I have a little brown. Oh, hold on. Yeah, I slid it in there.
Mr. Shaka.
Yeah.
I have no objection to the admission for essentially notice purposes of Mr. Stevens's emails and letters that are
Okay.
marked Exhibit 24.
Okay, thanks. Mr. Preston, are you looking at them or do you have no objection?
Let me, just give me a second. to
Sure.
flip through. No objection.
Okay. So go ahead and explain for the board the transcript issue.
Sure. With respect to the transcripts, in that this is the zoning hearing board's review of the underlying proceedings as far as what was under consideration both by the Bethlehem Planning Commission as well as City Council. What we did was make a right to know request, and we requested all the audio recordings of what are 4 separate proceedings. The first being the November 8th Bethlehem Planning Commission meeting. The second, and that's Exhibit 25 in this another notebook that I'll give you. Exhibit 26 is the November 20th, 2018 hearing on this subject amendment. Exhibit 27 is the Bethlehem City Council meeting on December 4th of 2018. Exhibit 28 is the December 18th, 2018 final vote meeting before City Council. We obtained all of those audio recordings of those proceedings, and we transmitted them to Veritex Court Reporting, and they transcribed all of those in their booklet form. And they have, all the testimony of the various witnesses on both sides. And I'm suggesting to submit the complete transcript, not just what's cherry picking what's favorable to the appellants, but the complete transcripts for this zoning hearing board's review and consideration to make a fair determination as to whether or not the subject amendment is valid.
Okay.
So that's the basis of the request. To the extent that there's objections on authenticity, I've asked Mel Bartman to be here to do the chain of custody of the audio recordings, the transcription, and the creation of these 4 transcripts. So I'm prepared to do that if we need to go down that path.
Okay.
But on the basis of expediency, convenience, I submit that this will streamline these proceedings and hopefully shorten this quite a bit, because there are a number of witnesses who we will not need to call, in particular the Bethlehem Planning Commission witnesses I wouldn't intend to call. We would just rely upon what they said at that proceeding. And similarly with certain other witnesses, and we can condense this proceeding if this board would accept these transcripts.
Okay, so question for, the witness you brought, Ms. Bartman, would testify that she took the tapes that were the tapes the city provided you, and what's in those is perfectly accurate or virtually identical to what was on those tapes to the best of her ability,
To the
right?
best of a
Because I'm sure there's
corporate-
words you couldn't understand, but okay. And then your position is those are identical. Instead of calling the witnesses, you'll have the transcripts of the 4 meetings, and you would say, I believe they're relevant to the underlying matter that you're going to decide, board. That's why I want to submit them. So there's really 2 issues. Can we do it by transcript, and is the transcript even relevant? So
Okay.
I guess,
Can I just respond to that?
yeah, go ahead. I'm just trying to figure out so then when they answer, I know what we're talking about.
I mean, it's beyond relevant to the extent that this is the actual transcript. These are the actual words. These are references to exhibits. These are the memos of Darlene Heller, references to the memos of Darlene Heller, as it occurred real time for this board to review, as opposed to a proceeding here where piecemeal will be pulling in, witnesses and trying to recreate what was before both the Bethlehem Planning Commission and then City Council to make the determination of the passage of this amendment. So I submit that this is really the best evidence of what this board really needs to review and consider in its determination as to whether or not what council did in passing this amendment was correct. To the extent that there are certain witnesses, and similar to how we do it when, say, it's a zoning hearing board matter that we appeal to the common pleas, there may be a need to call certain witnesses to amplify certain matters, to clarify procedural issues, and I'm prepared to do that. And I do have a few hand-select witnesses who I intend to call to do that. And then that's really for the board's purpose to really hash out and clear up certain issues that we're saying are certainly critical for our invalidity challenge to the amendment. I have a number of some case law, some precedent that I'd like to write. If you're going to turn it over to the other side, I want to make sure all of that's set forth.
Why don't you just summarize what those are and then hand the cases up and hand them to council?
Okay. The key principle in this board's consideration for the admissibility of the transcripts is the section in the MPC, section 53 PS 10908, section 6, which states that administrative agencies such as the Zoning Hearing Board are not bound by the technical rules of evidence, and all relevant evidence may be admitted. And on that basis, under the MPC, the more lenient standard for evidence, we'd ask that this board submits as evidence the underlying transcript. I am anticipating, because this is the phone call that I had from the city solicitor, that the city solicitor's argument is going to be that he objects that he wasn't present at some or all of these proceedings, and he would need a fair opportunity to cross-examine certain witnesses. The appellants submit that that's not a valid objection in the context of a proceeding where it's a public hearing for the consideration of a zoning amendment. The rules were set forth for this proceeding by Chairman Waldron, and he set it forth where he gave the applicant a period of time to make their presentation. Darlene Heller of City Planning gave her presentation. City Council then had their opportunity to ask questions, and then each witness from the public was limited to their 5 minutes. There was no opportunity to cross-examine any witnesses, so that challenge to these transcripts is invalid because it could have been done in the first place. Furthermore, there is authority to support that, and that is the Perrin case, which we're both actually referring to, but I'm referring for the important proposition that there is no right to cross-examine in this type of proceeding, and therefore that's not a basis to object.
You say in this type, you're not referring to tonight, you're
No,
referring to.
I'm sorry, I'm pointing to the transcript, but I'm talking about
Gotcha.
the City Council's consideration of the amendment. So the other point is there are references in the transcript to exhibits, which are in your notebook as well, all the exhibits that were submitted during the course of these proceedings. It's our position, whether they're letters from interested parties, whether it's a memo from Darlene Heller, those references and discussion of those memos is not deemed inadmissible hearsay in the context, this context of a consideration of a proposed zoning amendment. And the case that I have, and I'll hand that case out, and it's the appeal of Benich case.
Yeah. Sure.
And I've highlighted the relevant portion.
Thanks.
In that case, it was a positive case for the appellants in that the zoning amendment that was being considered was deemed invalid spot zoning. The key component of the case, I think I handed my copy. You get an extra one.
Yeah,
In there, the underlying record to the challenge to the zoning amendment in this particular case, a consulting engineer simply submitted a report, and that was relied upon by the governing body to make a determination as far as the zoning amendment. When that went up in appeal, there was a challenge saying it was inadmissible hearsay, but the court ruled, the Benich court ruled that that was a valid report. The written report was valid and could be considered because it was made a part of the record. So to the extent that there's any kind of reports or references to memos, what would typically be considered hearsay, because it was made a part of the underlying record and it was before city council in their consideration of the amendment, then it's not considered an inadmissible hearsay, and that's another reason to submit the transcripts in this circumstance as evidence in the case.
Which head note are you referring to?
It's not a head, it's a footnote. In the body of it, it's footnote 5. In the body of it, it's in that section 5. The court reached the finding by accepting the opinion of Fawn Township's consulting engineer in that section, and then it refers to footnote 5 of the case, which talks about the
So you're
consideration.
suggesting that that we have to, or the court in here had to consider what the consulting engineer's opinion was?
I don't know if it goes that far. I say,
Okay.
what I'm saying, I'm giving this zoning hearing board comfort that you can take this the transcript as well as what's in the notebook, which is going to be an argument in just a few minutes, the exhibits that were submitted to city council, and consider memos and what would typically be considered hearsay because it's part of the underlying record. And you have comfort in doing that based upon the Benich case, because in that case, similar situation, there was a consideration of a zoning amendment. The report of the consulting expert was simply submitted as a letter report that was relied upon by the governing body. When it went up on appeal, they said, that's okay. It's not inadmissible hearsay, we can consider it.
So the board could have decided here not to consider the opinion of the consulting engineer.
Perhaps that could have been the case. I mean, I think you have wide discretion, quite frankly. I mean, to consider, relevant evidence, and I think you have that consideration. I mean, you could do both. You could, admit the report, but if you really feel a strong need, we really wouldn't want to hear from a consulting engineer live and have either whoever's producing them, the applicant or the appellant, to have them live. So.
Okay.
Okay. The next argument is it's Exhibit 20. And you guys, before they turn to Exhibit 20, if you want to take a look at, this is a letter that I sent to Attorney Spurk, the solicitor for City Council. The letter is dated December 12th of 2018. And this, timing-wise, you have the timeline. We had the first vote at City Council on December 4th of 2018. After that hearing, and after hearing the input from City Council and how they were voting, I sent a letter, the letter that's Exhibit 20 in the notebook, to Attorney Spurk, and made a specific request to admit as part of the permanent record the 14 exhibits that I had already at that point handed up to City Council for their consideration up to that point. So I was creating a record to make sure I had already handed all these exhibits that I'm referring to in this letter to City Council, and it was before them for their consideration before their vote on December 4th, just to be doubly sure and to make sure it was going to be made a part of the record. I followed with this letter to Attorney Spirk asking him to make it a permanent part of the record. I never had a response from Attorney Spirk. There was no objection raised. So my legal position would be, well, any subsequent objection by Mr. Deschler, who said just earlier that he's representing the city, including the city council, any objection to these exhibits at this point has been waived because I gave him an opportunity, both at the time that I submitted them at the real time at the time of the hearing, no objection was raised. And then subsequent, I followed with this letter, which is Exhibit 20. So here are all the exhibits that I presented at the city council meeting on December 4th, make it a part of the permanent record, and nothing further was heard. So it would be my legal position. If you're gonna object, or let me know, or at least let me know before the December 18th vote, the second city council meeting, so I could make a further record at that point in time.
What's your authority for that?
The authority would be there's a whole line of case law as far as waiving objections. I mean,
but
if you're gonna,
sorry, that's at a formal proceeding. We're talking about a letter. I send you a letter and say, hey, I'm going on vacation to the Bahamas. I'm not going to be there. That doesn't mean that, you can't still raise an objection about that.
Yeah. I would say, okay, come on. You've been given multiple opportunities to raise objections to these exhibits. You were given one opportunity at the time of the hearing. You were given a second opportunity when this letter was sent. Okay, now here we are up on appeal, and for the first time, we're gonna hear an objection to those exhibits. And what's your basis? Moreover, no matter what the content of these exhibits are, I think it's important for you to have the complete record, to have all of the evidence, all of the letters, all of the memos that are in that notebook that was before City Council when they made the vote. And you, as the zoning hearing board, have, like I said, a wide discretion to give this evidence the weight that you feel it deserves. I would submit that you let it in and you look at it and then you decide the weight of that evidence. The important thing is not to exclude or cherry pick things out, that items that were before the zoning, that were before City Council making their consideration. My position is, I think it makes most sense to submit the transcripts, submit all the exhibits that were before City Council, and then give it that evidence its appropriate weight.
This pertains, though, to the exhibits, not the transcripts. In other words, in theory, could the board rule it won't take the transcript, but it takes the underlying? I mean, they're two. You're talking two different things, right?
They're blended because there's references in the transcript.
All right.
To all of these exhibits, and it makes the transcript obviously reads and makes much more sense when, okay, Darlene Heller is talking about her December 3rd memo. Where is it? Okay, well, it's right here. You have the complete record. That's what I'm suggesting, and that's to piecemeal it out. I think that'd be really inconsistent. And what are they doing here? Because you're excluding, certain documents that were all part of the permanent record, but. So anyhow.
Okay. Okay, I'll come back to my other question.
Yes, the city does have an objection, as reflected in my letter to Mr. Schock and Mr. Stevens, Mr. Preston. The issue isn't so much with the accuracy of whatever transcripts are being produced. The issue is with the fact that the statements, any statements, I'll call them statements, not testimony, the statements made in proceedings before the Planning Commission and City Council were not under oath. Mr. Sean started out this proceeding tonight stating that witnesses would testify under oath. The MPC provides that at a zoning hearing board hearing, witnesses testify under oath. None of these statements were made under oath. We're essentially importing unsworn statements into this proceeding where testimony needs to be taken under oath. It does need to be sworn. I think on that basis alone, you can exclude those transcripts. It's not, we don't even get to the issue of relevance. We get to the issue of competency. In competency, one of the elements of competency is that the witness understands the oath that one takes when one testifies. So because that wasn't done at planning commission meetings or at city council meetings, we cannot admit those transcripts. In addition, Mr. Stevens makes reference to the fact that the city, that, as I said in my letter to Mr. Schock, I was not there, or an attorney from the city solicitor's office was not there. That's not a minor detail. It's not so much that no one was there, it's that the city isn't a party in those proceedings. The big issue here is with the substantive validity. That's what the challenge is tonight, to the zoning ordinance amendment, which was enacted by city council. And let's keep in mind, when this matter is before city council, there is no ordinance. I'm here defending the validity of an ordinance. How can we defend something that hasn't even been enacted yet, which is what the situation was when this matter was before city council? There's nothing to defend, ergo we're in a totally separate or totally distinct situation here where the issues are very different. I'm here defending the validity of an ordinance that wasn't even enacted when these transcripts were made, or when the matters reflected in those transcripts occurred. So we're in a different situation here. Finally, Mr. Stevens kind of leaves out a lot of the MPC when he talks about how formal rules of evidence don't apply at zoning hearing board hearings. He leaves out the fact that, and it's in that same subsection 6, formal rules of evidence shall not apply, but irrelevant, immaterial, or unduly repetitious evidence may be excluded. In other words, Mr. Preston and I can make objections to the evidence presented by Mr. Stevens, and this board can sustain the objection and exclude it. To say that the formal rules of evidence don't apply doesn't mean that everything goes out the window and everything comes in. There are standards of evidence here, just not as stringent as those that might apply in common pleas court. So I do have the ability to object, an ability that I did not have at the planning commission meeting, at city council meeting, when the city is not a litigating party to the proceeding. Finally, to wrap this up, again, and Mr. Stevens omitted this from his presentation, subsection 5 of section 908 of the MPC indicates that the party shall have the right to be represented by counsel and shall be afforded the opportunity to respond and present evidence and argument and cross-examine adverse witnesses on all relevant issues. And I think Mr. Stevens, in fact, said, he acknowledged that at city council meetings and at planning commission meetings, we don't have cross-examination. That's not the kind of proceeding that is. Whereas here, we do, pursuant to statute, I have the right to cross-examine any adverse witnesses, a right that I was not afforded and the city was not afforded at the prior proceedings. So I would say for all those reasons, these transcripts cannot come into the record tonight. And I guess with respect to the separate issue of the exhibits, first, I'm not really sure I understand that, but I will say this. Mr. Spurk is the solicitor for Bethlehem City Council. I am not, to be clear, I am the solicitor for the city. I am here, even though I'm defending an ordinance passed by council, because it is the duty of the city solicitor's office to defend the validity of city ordinances when they are challenged. So that is why I'm here, and I'm obviously defending an ordinance after it's been enacted. Mr. Spurk, as I understand it, I don't think I was at those proceedings, was advising council, as he does at every council meeting. And with respect to whatever was presented at city council, as Mr. Stevens knows, in the procedural validity challenge, now pending in common pleas court, I have vigorously opposed the introduction of everything under the sun that was attempted to be, quote unquote, introduced at the city council meeting, because as I indicated in my filings in common pleas court, that evidence was not presented under oath. We don't really have a record of it being accepted. Essentially, the appellants here, I guess objectors there, just hand up a bunch of documents to council members. It's not like they're formally passed on and admitted into evidence, or there's an opportunity to object or anything like that. So we don't know what was considered. We have no real record of what was considered. When I produced and compiled and produced a certified record that I submitted for the appeal to the procedural challenge, I did not include all those exhibits, as Mr. Stevens knows. He objected to my decision not to exclude or not to include those exhibits, which was not really ruled upon by Judge Corey, who just scheduled this matter for a non-jury trial. So Mr. Stevens has taken this position before. I'm opposed to the position he's taken with respect to the exhibits. If he has them here, what I would suggest is that he have a witness who can authenticate them and present them tonight for the board. Thank you.
Mr. Deschler, isn't what he's suggesting, though, something akin to legislative, the legislative history of how a matter came before the ultimate determination on the ordinance? So it was what happened at, let's say, committee meetings or those kinds of things, which are not under oath necessarily. But isn't it part of that legislative history?
I understand the point. I suppose I would agree with that. I suppose my argument or response would be that that is still not admissible at a zoning hearing board hearing where all evidence, and Mr. Stevens has represented that he intends to introduce these statements as evidence, where evidence must be taken under oath. So I think it's not just the deliberations that he's presenting of council members and planning commission members. He's presenting obviously as well the statements made by people who spoke at those meetings, and because that's the nature of the transcripts and what Mr. Stevens intends them to be used for, I do think they need to be introduced under oath. But I suppose in the same way that I mean, for example, like Senate committee hearings, they are under oath. Witnesses speak under oath. But in terms of the deliberation of legislative bodies, which I don't believe are under oath, I would agree. It's kind of like legislative history. I don't think it's relevant to the issue before this body, which is whether the text of this zoning ordinance amendment and its operative effect on the city's zoning scheme is substantively defective. So I don't think it's relevant to that issue, to a substantive validity challenge. And before we get to that point, I don't think that sort of evidence, the legislative history, is relevant, and I don't think it's evidence that's presented under oath.
Thank you.
Go ahead.
I really would like to say something here because I'm kind of struck by the irony of this request. We're here purportedly because there's been a violation of due process that the applicants would like to see corrected. Now, as Mr. Deschler said, the MPC does state that the party shall have the right to be represented by counsel, shall be afforded the opportunity to respond and present evidence, and argument, and cross-examine adverse witnesses on all relevant issues. And as Attorney Stevens has conceded, the transcript of the hearings that he wants to put in, there is no right to cross-examine. The witnesses weren't sworn. And we have essentially unreliable, I wouldn't even call it testimony at this point. Is there a reason to bring them in here? Perhaps. And the reason depends on what's the purpose of the offer. The purpose of the offer is to show that, hey, they had hearings. They did, and this is essentially when they had them. That would be a legitimate purpose, and we could handle that by a stipulation. But that's not the purpose of the offer. The purpose of the offer is to establish the truth of the matter asserted in that testimony, in that unsworn testimony. That's really the only purpose to bring those in. And if you follow the pleadings and you've read the application to the zoning hearing board, what immediately becomes obvious is that where we're going here is we're seeking to investigate the legislative motives and methodology that go into adopting, in this case, this particular legislation. And I think that's a wildly irresponsible undertaking for a zoning hearing board to examine the motives and methods in adopting the ordinance. That's not part of a substantive validity challenge. There are no cases that include that. My colleague's not going to find any because that's not something the judiciary engages in. What the courts do, and essentially you're acting as a court, is you have to focus on the amendment itself, and the amendment stands or falls on its own terms. It doesn't matter if there was an impure motive in adopting a piece of legislation. You don't strike it because it's an impure motive. You don't say, I don't like Ted Cruz, we're going to get rid of that. It just doesn't work that way. They adopt it, you examine the legislation, and it's either it either stands or falls on its face. So really what's important here is what occurred as of the effective date and thereafter, not reams of unsworn testimony that occurred at a city council meeting where different people were expressing different views that now needs to be imported into this hearing without any right to cross-examination, to cross-examine the witnesses, any way to test the veracity of what they're saying, and simply have it embedded here for the truth of the matter asserted. I think it's dangerous. That in and of itself, I think, is violative of due process. But I also think to embark on an investigation of the legislative motives that went into this is wrong. And I think it's beyond the scope of these hearings. I don't think the judiciary should be engaging in that. I don't think they do engage in that. The ordinance speaks for itself, and the applicants can make their case just as everyone else who's ever presented a substantive validity challenge to a zoning hearing board or to a court. That's not through an examination of what the people were thinking when they adopted. What they were thinking is not relevant to the validity of the ordinance. Thank you.
Yeah, so one of the things, Jim, Mr. Preston said, so that I think needs to be considered is what is it offered for? So in other words, if someone came in and said, to decide whether the ordinance is valid, you need to at least hear what the people who made the decision heard, whether it was true or not, right? Then would it be, if it were relevant to simply say, I'm giving you this because you need to see the totality of what the council heard when it passed that ordinance. Does that mean, do you think it's excluded in that instance? Even if you're saying, I don't care whether it was true or not because it wasn't under oath, but you as a zoning board need to hear what went on.
So that
Is that relevant?
I don't want to jump.
No. Do you,
Yeah.
and I'll let Mr.
No,
Stevens
what
answer,
I don't think it is at all. What you'd be doing in that case is second guessing city council. You would be exploring why they made the decision that they made. And city council is under no obligation to explain to the zoning hearing board why they made the decision they made. They made the decision. Now you have the decision. The decision's out there, and it's up to the applicants to demonstrate that that ordinance violates due process, substantive due process, whatever it is. That's their challenge. What we're being asked to do, I believe, is to engage in a critique of city council's actions. Should they have done it? Should they have not done it for these reasons, those reasons, or whatever? I don't think that that's what this should be about. This should be about the actual ordinance, the ordinance itself. Is it directed at a single property? If it is that property indistinguishable from properties that surround it? Does it have no distinguishing characteristics? The rules are out there for evaluating ordinances. The set of rules that are being suggested now, I got to tell you, it's bizarre. I've never seen this before. I have never seen a request, never, and I've never read a case where the courts went back in, opened up the legislative record, and critiqued what the legislative body did. I've never seen that. They stay away from that. In fact, the presumption is, and the attorneys know this, the presumption is that legislation is valid. That's the presumption that goes in with that presumption. It's up to the objectors to show that it is not. And the rules for showing that it is not do not include an examination of what the legislators were thinking. It includes an examination of what are the effects of the legislation. Is it directed at a single property? Is it discriminatory? Is it spot zoning? Is it what? It's not what they were thinking, not whether the chairman of council is a good guy or not. That's not what this is about.
Well, yeah, because I still come back to, I think the issue is is that truly correct? That there can be no consideration of, for example, what the council heard, or, you know, a council member's, well, if there was a record and a council member said on the record, I want to do this because I love the color blue. And everyone looks and says, well, what is that going? Does that, your position would be, doesn't matter, right? Doesn't matter why a council person said they were passing this. You're saying that's irrelevant, which is why you don't admit this. Am I understanding that? Because I think he's arguing that the reason they did this doesn't, I mean, that's the argument. There may be case law to support that, but I just want to, I need the answer on that.
There's case law to support it. And
Okay.
I don't want to speak out of term, but I can
Sure.
recite the law that applies. Apparently, Mr. Preston has not read the appellate decisions that apply to this process.
Okay.
The process of a zoning hearing board and the higher appellate bodies reviewing an amendment to
Okay.
zoning. So-
Then I think that's what we need to go. We need your position on that, because I think we've reached the point where I understand their position, but if you are correct, then we have to consider the case law to support the idea that it becomes relevant.
Mr. Sharkey,
And
Yeah.
the
I'm sorry,
Hold on a
I'm gonna
second.
say
if I may.
the
Huh.
case
Okay.
that I was referring to,
Yeah.
I don't know if you want me to continue.
Well, we'll let him say what he needs to say, and then we'll come back to my question to you, which is, give me the case law that says we have to consider it.
I think essentially what the board, as I understand kind of the thinking from Ms. Shea Gardner and Mr. Schock, I understand the idea of that if Mr. Stevens is offering the transcripts to in effect demonstrate an effect on the listener being city council. And I think to do that, then you would have to almost consider what, if any, statements city council made in their deliberations in response to those, in response to the comments made by the members of the public. I think it's difficult to do that unless, for example, council members are specifically referencing a certain comment that a certain member of the public made. I don't know how else you would kind of divine what council members were thinking when they made their decision. In addition, it's my final point.
Mhm.
I still think if at some point though, what is said is relevant. Now maybe, or what is said has to be taken for the truth. If it's not the speakers, and if it's only how council members were affected by the speaker, then at the very least, it is the council members' statements that must be taken by this board for their truth. In other words, if some council member said, well, Herm Ridge, wrote a $10,000 check to my campaign, and that's why I'm voting for this amendment. I know it didn't happen. I'm just saying that's why I'm voting for this amendment. That would still have to be taken for it. That would have to be taken for its truth. And what I would argue is a statement like that would have to be offered under oath for this board to consider it for the truth. I don't think at some point you have to say, well, none of these statements were made under oath. When this board considers the matter, we have to take statements that are offered for their truth to be under oath. And if none of the statements were made at city council or at the planning commission under oath, this board cannot receive them and cannot consider them.
So give us the case law, if you could, that you think makes this evidence relevant. 'Cause
I mean,
think
this
that's
is
the,
one of a number of examples.
Sure.
I mean, there's a whole line of spot zoning cases where the reviewing body, the zoning hearing board, and then it goes up, common pleas, up
Right.
to the Commonwealth Court and maybe
Yeah.
beyond. They're exploring what the thought process was and considerations of the underlying record and what the board members were deciding and the basis for their decisions. That's exactly what this zoning hearing board is charged to do. And the case is the Baker versus Chartier Township Zoning Hearing Board, 677 A second, 1274. I picked that case because it aligns with our situation in that it was a challenge to a zoning amendment and it was deemed illegal spot zoning. In that case, there was a parcel adjacent to a landfill and it was deemed illegal. Key to that case was the zoning hearing board in its determination failed to evaluate the impact of the zoning amendment and failed to properly assess whether or not it comported with the planning, the comprehensive plan of that township. Those are key issues that are in this record that I'm asking this board to review, because both of those things were not done. And I'll even read to you to demonstrate to this board that you are to delve into what the thought process is of city council and what their bases were in making their determination. And yeah, there's a lot of irrelevant information in these transcripts. That's our position. That's why the zoning amendment is invalid, because there were irrelevant considerations. Yes, he pays going to pay $100,000 in taxes, or he's going to donate to the mounted police. There were all these irrelevant considerations in their final determination. But let me just read.
Before you get there, just sorry, pardon my interruption, but was that one particular property, or was the ordinance related to a number of properties that would have been spot zoned?
In this case, this is a parcel adjacent to a landfill from agricultural to industrial was illegal.
So it was on one property.
I would have to delve further into the facts to see exactly.
I think that sounds like it was a map amendment,
Correct.
but so the facts would be different, but read us the section you were going to read to see if it's general enough on the principle we're asking you the question on, which I think that's the essence of the dispute between the both sides here is this one. Do we need to hear these things, or as Mr. Preston and Mr. Deschler suggest, for a variety of reasons, we shouldn't be hearing them, right? So,
right. It's why and this court certainly heard them, and the court's saying, this is the Commonwealth Court, we agree with the trial court that the procedural irregularities indicate that the board failed to make full and fair examination of the impact of the rezoning in its attempt to accommodate Martin being the applicant. Because of the sanitary landfill's prior and potential ability to generate funds from the host agreement, and because the host fees allow the board of supervisors to keep down taxes in the township, the environmental impact of the rezoning and its conformity with the comprehensive plan was not sufficiently explored by the board. They're looking at what the board did, what the board in this case failed to do. That is all in these transcripts, because one of our number of key arguments, one of our main challenges is that city council failed to adequately do their due diligence and conduct sufficient research to determine what the true impact of the zoning amendment is. Another key argument, which is here in the Baker case, is the city council failed to do its due diligence to make a determination as to whether or not this zoning amendment comported with the comprehensive plan. The only way you're going to learn that and be able to review that is if you review the transcript and have that evidence of what city council heard by way of testimony, what they reviewed by way of exhibits, so you can make that determination if in fact city council dropped the ball and should have done more by way of due diligence, should have done more to see if this zoning amendment comported with the comprehensive plan.
So is it your position that we are allowed to second guess what city council did then?
You're there to review what city council did to make a determination if they adequately explored the basis of this zoning amendment, to make a determination if it impacted just one property, if it impacted 3, if it impacted 64. It's our position that wasn't done. And you're here to review this record to make a determination if, maybe it was adequate, but maybe it wasn't. And you agree with the appellants that more should have been done and this amendment should be stricken. And that's one of a number of issues, but there are plenty of others where you need to review exactly what was before the city council in these transcripts to make that determination.
I guess I didn't hear that in what you recited about the Baker case. So what are you saying in that Baker case specifically says that we should delve into those transcripts, which are not under oath, et cetera?
Because they would, in order to make that determination, the reviewing court here had to know what the board did. How could they find that out without having the underlying records of what the board did and or didn't do?
by having witnesses testify at a zoning hearing.
That's our position on that is, okay, we're going to replay every single aspect, every single witness, and recreate what's already basically been done. I don't think that's the function of the zoning hearing board. The zoning hearing board, in this instance, is a reviewing body and is there to review, to make a determination as to whether or not this zoning amendment is appropriate and what council did in its passage was appropriate. I mean, they're specifically saying that it was an improper decision on the board's part to accommodate Martin, the applicant. So they're looking at what the board did in this circumstance. How else can you learn that without reviewing the underlying law?
Well, I guess I have a question. I mean, could theoretically someone come in and say, I'm challenging the ordinance, set up a tape player, and then just play the recordings for 9 hours straight to a zoning hearing board? Right, I mean, because you can use an audio recording as evidence, I think, correct? I'm not asking someone to do this. I'm just saying, in essence, this is, please don't. But I'm just wondering. I mean, that's what he's saying is, right? Wouldn't the best evidence of this theoretically be if someone came in and played the tape, if it's relevant? That's what I'm asking.
I would agree with that. If it's relevant, and obviously they have someone here who purports to be able to authenticate
Right.
the transcripts. I have no reason to doubt that.
Right.
Right. So if I think maybe we're skipping a step in that, I do believe Mr. Stevens wants to introduce some of the statements in these transcripts for their truth. But
Right.
if
I've got
right,
you.
right.
I'm saying I don't know that I'm worried that much about the transcript, because theoretically someone could come in and have the right to play say I'm going to play these tapes. Sit here, folks, and play them. Right. So it's really not the transcript itself. It still becomes, should we be hearing that whole discourse either through reading it or hearing it live? Which goes to your issue of there's other issues why it shouldn't be in, right?
Right. And I still
Yeah.
think that with the transcripts themselves, if you're considering the statements
Right.
made by, for example, council members, I still think you would have to consider those for their truth. And therefore, I think that those statements would have to be under oath. And obviously they weren't.
Right. And that wouldn't matter if someone came in and played. If we sat here and listened to it, it'd be the same objection, theoretically.
Correct. Because the recording still wouldn't be under oath. The council member statements would not
I
be
get
under oath.
that.
No right to cross-examine the whole.
Right.
Correct.
So right. So we still come back to while there may be things that impair this evidence on that. So you've really got an argument that the evidence is imperfect to begin with, and then we have a separate argument of is it relevant? Should the board be learning or listening or reading or hearing the entire the entire board hearings, right? Okay.
Respectfully, may I respond to as far as the ability to cross-examine, they have every opportunity to do that. I've shared with them the transcripts. The witnesses are all there. They attended the hearings. If they want to call any of these witnesses and cross-examine them, now they're in better shape. They have
You're
the
saying they
transcripts. They
could
can
call
cross-examine
them.
them even more because now they have transcripts that they can cross-examine them and get more information. If the concern here is fairness and ability to cross-examine and making sure the truth comes out, they have that ability. They can call, they can subpoena anyone. Of course, the chairman would have to issue the subpoena, but subpoena any one of these witnesses, cross-examine them till their heart's content to make sure the truth does emerge. What I'm saying is that I think you're really hiding the truth because you're excluding from your consideration that legislative history, everything that transpired with respect to the considerations, all the evidence, all the testimony that city council considered, and absolutely what city council considered and the bases for their determination is up on review, and it's replete in the spot zoning cases and other cases dealing with rezoning.
Do you have a case? I understand the point you're making using that Chartiers case. Do you have a case though that I think answers Chairman Board Member Gardner's question, which is one that just says you should be listening to that transcript or listening to that hearing. I think, is there one that says that? I'm not saying that means the decision's being made. I'm just curious if any of those cases say somebody did what I suggested, which is they came in and played a tape of exactly what the audience and the council said at that meeting. Is there a case that says that you're aware of?
I don't know if there's a case that is that
Specific?
but
Okay, fair
reviewing,
enough. I mean, you can't write it.
But in reviewing the cases, it's clear to me that the reviewing governing bodies are reviewing an underlying transcript, that they're looking at the evidence that was before the body that made the actual determination, whether it be a township or whether in this case be city council. If you read those cases and you read them carefully, you can see they have the underlying transcripts of those proceedings. Not in all of them, I would assume not in all of them, but in a good majority of them, because there's no way they could be reaching these findings of what the board did and didn't do if they didn't have the
Is the Chartiers or whatever, is that case, you think the best one, and do you have a copy of it for me?
I have my writing on it. I don't know that I didn't make a copy.
Okay,
of
no
this.
problem. I mean,
I have my writing.
I know this is,
So
okay.
not my, there you go.
I'm sorry. May I?
Yeah.
I think the very invitation by Mr. Stevens that if the city wants to contest things that were said in these transcripts, that we can call witnesses, suggests that it matters that we accept what's said in those transcripts for the truth. Because if that's not the case, then why do I need to call anyone to testify adversely to what was said, or why do I need to cross-examine anyone who's made statements reflected in those transcripts? If all that matters is what was said, then I think the invitation to cross-examine anyone or call adverse witnesses is superfluous, because there's in effect nothing to contest, because we're not contesting the truth. So I think that very invitation by Mr. Stevens, I think gets to the core of this. We are concerned with what was said in there for its truth. We are concerned with offering the statements made by planning commission members and city council members for their truth. Because that's the case, I don't think it can.
Okay, this may be jumping ahead a little bit, but I think it'll help us on this question, which is, what if Mr. Stevens asked us to subpoena the entire council and all the members of the planning commission? I mean, is it anyone on your side of the table saying you can't do that for a reason? In other words, would that be equally irrelevant in your minds, or is it actually getting closer to relevancy if that's the alternative? Because you're saying he can't use the transcript. This question still becomes, okay, if he can't use the transcript, he can't use the video, should he be subpoenaing? Because in theory, one of the arguments could be they have nothing relevant to the proceeding before you, right? Because we're past that. That's a legitimate argument. I'm just curious, because we'll get on to the subpoena issue later, but I think what the arguments that both sides are preventing makes us almost ask that question now, right?
I think if you called members of the city council and the planning commission here to testify under oath, that would solve the problem that I sort of raised, where you have the transcripts offered for the statements that were made to show the effect on the listener, and therefore you don't need those statements offered for their truth. But then you have the council members here who are testifying under oath and who are making statements that are offered for the truth. So it would kind of close that problem or solve that problem. However, I obviously have the underlying objection that none of this
Is relevant.
is relevant.
Gotcha.
Because what we're concerned about is the text of the zoning amendment and its operative effect on the city zoning scheme.
And I guess the reason I'm leading people down that path is it seems like the only thing we can't correct by doing something differently is whether it's relevant or not legally, right? Because we can fix them by playing the tape so that we're not reading it. Then we say, well, it's still hearsay. Okay, we could bring people in under oath. We still get down to that baseline determination of, is it even relevant to be doing any of this? Or is it an exercise in futility because we shouldn't be even thinking about it? And Mr. Stevens is saying under Chartiers and the other cases, it's absolutely relevant. And your argument is it's not relevant, right?
No, it's neither one of those. There are standards that the courts have developed to evaluate whether or not a zoning ordinance is defective. and they're pretty well known. Whether it's a map or a text change is one of the first considerations. If it's a map change or if it's a text change, what does it control? What areas are in play? Are they, if it's a spot zoning challenge, which I believe we have here, is the area that's in question, is it indistinguishable from surrounding properties? I'm not going to go down the list. You know the list as well as I do. And then there are other considerations. The courts talk about the comprehensive plan. They talk about whether it's arbitrary, whether it's unreasonable. And those are matters that are explored in hearings through testimony, because someone may come in, a planner, with the opinion that it is unreasonable, but upon cross-examination, it may turn out that that opinion is really not well-founded. That's how it's supposed to work. What they're asking you to do is to jettison all that, do a document dump, and then rely on that for the truth of the matters asserted in the document dump. I'm not saying that Mr. Stevens is incorrect in that you can't consider whether it's irrational, whether it's arbitrary. You need to do that. And if he wants to put on evidence of that, he should be doing that. But to go back and explore the transcripts that happened in front of the hearing and dumping them in toto, I don't think it's correct. I don't think it's proper.
What was the, if I may ask, what was the case that Mr. Stevens had cited? Was it Streck? Is that?
No.
Okay. Oh,
Chartiers, 677 Atlantic 2nd, 1274 is the one he cited for this
And
this
may I just
issue.
respond to the comments about it being a document dump? It by no means is a document dump, because it's actually meant to shorten these proceedings, because they're witnesses who got up in front of city council and gave their statements. And the idea is, are they going to really say anything different in a hearing? No. And we can rely upon those transcripts, because that really is the best evidence here, because that was what was considered before the board in their passage of the act. Where this will be shortened even further is we'll rely upon these various transcripts, cite to them in the findings of fact and conclusions of law, and then in this board's final determination can adopt whatever they feel is appropriate. So again, that will thin the documents that you have to ultimately review, because there'll be specific citations to the record that support what counsel is advocating on behalf of their respective clients. So I'm actually suggesting this to streamline these proceedings. And at the end of the day, this board, and it's in the MBC, has and the supporting case has very, very wide discretion in its determination of what is relevant, and can make then the determination. You submit the evidence, admit it, and then make a determination as to its weight. And to the extent we call live witnesses and you hear from them to clarify various issues, and there are many issues in this challenge, including procedural issues where we do need the live witnesses beyond the bare transcript to clarify things, and we'll bring them in and talk to them. But the core of this, to have the underlying transcript that was before city council, I think is intrinsic to your duty as the zoning hearing board to review that legislative history, and then to take any additional evidence that is deemed appropriate to clarify the issues that we're raising on appeal and that they're responding to.
Can I just ask for a copy of the case? Can I see what you have there? The Chartiers case? I mean, if we're going to argue about that, can I at least be entitled to look at it?
Sure. I mean, it's got my notes on it. But
I just like to note a case for the record. This is Streck versus Lower Macungie Township Board of Commissioners. It's a Commonwealth Court case from 2012, 58 Atlantic 3rd, 868. A court may not rescind a properly enacted zoning ordinance that applies to the general public. To avoid an ordinance on substantive grounds, the challenger must show that the ordinance is arbitrary or unreasonably discriminatory or without substantial relation to the public health, safety, morals, or general welfare. Further, the court will not inquire into the motives of a municipal legislative body in making zoning changes.
Okay.
And that's not the sole issue. It's not just the motives that we're looking at. We're looking at the factual determination was before the board, whether or not they did their due diligence, whether or not they properly looked at the comprehensive plan. We're looking at the confusion amongst city planning as well as the applicant in the actual language and the ambiguity of the language that's borne out in the underlying transcripts. And we'll bring other witnesses in to further clarify those issues. But to start fresh without having that, what preceded you, and to try to start fresh and recreate essentially 4 evenings of hearings, I mean, what is it, 10, 15 hours of proceedings, I think is counterproductive in that you'll have what went before you, and then we can call a few individual witnesses and clarify.
You have a copy of Strack?
No, I was, these are part of my examination notes for tonight. I don't.
Oh, okay.
Sorry. It was convenient enough that the
No.
code appeared in what I had.
All right.
Should we go off the record?
Oh,
Yeah, let's go off the record.
We could use some.
I mean, to give, before, I don't know if you're going to make a determination, but I think to give this more context and to better amplify the need for both the transcripts as well as the exhibits that were before the board, I mean, if I can outline the framework of what our challenge is to the zoning amendment, it may elucidate the value of having the transcripts.
I don't think we're there yet.
Okay.
That's just my
Yeah,
personal
well,
opinion. I just don't think, yeah.
I guess I would say, does the board want to discuss this? And if
Yes.
you
Yeah.
decide that you need to take Mr. Stevens up on his offer, you will do so.
Correct.
Okay,
correct.
let's do that.
We're going to go off the record in an executive session for a few moments.
You can have my block quote if you like.
Oh, okay. That's
You have a copy of this?
No.
Take this with you.
I'm going to take your copy of that.
What is he handing you, just so I have a copy, whatever?
Is there another plug over there?
An outlet?
The rest of it can.
Like here, is there?
It's the only one.
Is it just the site or what do you?
Traffic
Well,
light
this whole
machine
block
is
quote
going.
I pulled out for contract zoning.
If you need another outlet.
What do you,
No,
for what purpose?
asked for the, yeah, that's.
Okay.
I didn't hear, what'd you say?
If you need another outlet, I can unplug the laptop.
No, I have an extension cord here.
Okay, gotcha.
So
It's not looking good for you.
for different strategy, if they accept it. The strategy already to start running through what our 8 their points are.
Both,
Zoning ordinance of flawed.
correct. Barring any technical challenge.
Once you can start to put your case on, which I guess you will be
Yeah, I think that would
eager
be.
to run through the 8
Yeah.
main things.
You have to link to the YouTube site. They're archived on the YouTube site.
Sounds like he's trying to.
You should be able to.
By virtue.
You absolutely should be able to. And if not, send me an email and I'll figure out how to get you connected to it.
Whatever you're talking about.
I'll get you one.
Oh, we're broadcasting.
Yeah. Yeah, okay. Start. Threatened. Preston's. So the corner. Apartments. Wherever you want me to talk.
Whatever you say. Little example.
It doesn't hurt, right? Right. No, and I agree. I don't think anybody would be successful in challenging seating based on certainly the relevant if it was one of the typical CHP cases.
That's like kind of what Eric was saying. It's almost like if like if you could like put something and have it write things to the wall, that doesn't make any sense.
Right, right. Or what, the alternative?
Yeah, right.
RT and RG districts and. You know,
Yeah, I think I would want to use the winner.
you know, it's like city ID badge on it. Some people are okay with you, but most are not.
Opportunity for deference or shot in the face.
You know, usually when we go out, it's because somebody's had a violation. So the conversation is writing a letter.
That's what I've always had, like, you really have to. No one wants this. You try to work it out. Yeah.
The moment we go down that route,
I could. If you really want to, that's going to take care of you. You can lean your property that's with 100. Yes, sir. Never execute because we're never get our money back. Nothing.
right.
And city will never collect on it.
Yeah.
No, for whatever reason.
Over here too.
I have
These aren't on me. Oh, here, it's not up here.
Well, better.
I'm getting the texts.
Take the live stream. Can't figure out how to edit all that. I can get it.
A little bit of that. I don't know. I don't know. I I see your report. You want to go 3 for 3? You lose most of those you do. It's just the nature of. My friends and I, we do the trivia there every Wednesday night at 8 o'clock. So I told them I would come if and when we get done. About 3 hours. You're there for a while.
This one
Yeah,
here,
I
right?
read that in the paper. Yeah,
That's yours. Was this one yours too? Was it stuck to the back of that one? Okay, that's the other one, the first one, right? Got it. And that's yours. Yep. I got the numbers. I just, I didn't know how they would pick the real me. Is that what we should? Okay, I thought so. I'm like, I usually know how to play that game. You know, it's like, I'm such a habit.
Yeah. It's a nice bunch.
Let's do that every
Like
time.
sitting on the table.
Gladly.
So everyone's, and then. you can say, we're gonna.
Gene, can we go back on the record, please? Thank you very much for your patience. We would like to restart the hearing again. after receiving some advice and discussion with our counsel. At this time, I would like to entertain a motion.
I'll make a motion to deny the requests in Mr. Stevens' letter of 9/3/19, specifically letters A to D, as not being admissible. And this includes not admissibility to the transcript in 24 and the documents in tab 20 in your 2 exhibits.
I'll second.
Mr. Piper, could you take a roll, call the roll, please?
Certainly. Mr. Novatnik,
Yes.
Ms. Shea Gardner,
Yes.
Mr. Shantz.
Yes.
And to be clear, it just pertains to the manner in which it was submitted. I mean, you're free to make your case in
Mhm.
other ways with regard to that evidence.
Okay, I'm just not clear as far as the subpoena, because the subpoena was included in Exhibit 24.
Right, but she said the transcripts labeled A through D in your letter of September 3rd. That was the only, those were the 4 transcripts, correct?
Okay,
Okay, so if, am I
That's
correct?
correct, that's correct.
So your letter of September 3, 2019 had A through D where you listed the 4 transcripts, the 4 hearings that you wanted transcripts from, correct?
correct.
Okay, and then you also said at this meeting that those include by reference at those meetings, and if I'm correct, the list of exhibits in number 20.
Right.
Okay, so that's what you were asking that we just take in as, I think what was called, like a document, those documents. And what we've ruled is we're not going to take it in through the transcript. And that includes not taking the documents as part of that transcript. But you're free to proceed with the alternatives, which now I presume you're going to say, I'm going to call witnesses or I'm going to ask for those subpoenas. Is that what we get to next, right?
Well, I think procedurally, we're at the subpoena issue.
I agree.
Next.
I think
I
you're right. Yeah. I mean, that's what I said before when I was talking to counsel, which is, isn't that what comes next? We discuss whether you should be subpoenaing some of these people. We got to go to that, right?
Correct.
Okay.
Right.
All right. So, why don't we start with, I think these fall into different categories. You am I correct that you're requesting a subpoena for Darlene Heller, the planning director?
That's one of the subpoenas.
Right. So let's start with that one, because obviously she's not an elected official. She's the planning director. I'm not sure of her exact title for the city.
Correct.
She's the planning director.
Oh, okay. Then I am sure of her exact title. She's the planning director.
And
I
she's
just wasn't positive.
on vacation until Monday.
Okay.
I think, and I'm not going to speak for my colleague, I'll let him speak for himself, but I don't have an objection to these people coming here, being ordered to come here to testify. Although when they're here, we still reserve the right
Right.
to make our objections at that time.
That's fine.
Okay.
I think though the board still, the question still becomes, there is a standard when a board is going to issue a subpoena.
Mhm.
Okay. So I guess, thanks for cutting in, because we'll start with this. If the board determined it was going to issue the subpoenas on the 4, let's put all four people. Are both of you saying you wouldn't object to the issuing of the subpoenas, but you were reserving your right whether any of the testimony was relevant? Is that what you're saying to me? Or do you want to object to the subpoenas? I can do this either way.
I guess I do not have an objection. I'm not sure, for example, to the extent that I could even speak on behalf of Mr. Malozzi and Ms. Cohen, the 2 members of the City Planning Commission. But no, I would agree with Mr. Preston. I have no
Okay.
opposition to the issuance of the subpoenas.
Okay, so then let's start, but I think the council can weigh in, but my understanding is I think there's one case about subpoenaing people in zoning hearings. And I think there's the MPC reference to it. And I think that case did nothing more than make clear that an applicant is allowed to request subpoenas, but they can't just say subpoena X. They need to give us a reason so that we know that it's relevant. And the reason I put Darlene Heller first is we're talking about a zoning amendment. We're talking about planning issues. I think the board's position is certainly the subpoena should be issued on Ms. Heller, you've done this, and I only say certainly because you have done this before and made the determination when in cases people have planning questions, they have asked us to issue subpoenas on for Ms. Heller. So go ahead.
Yeah, and we just had this issue. I had something Penn Forest Township, represent the Bethlehem Authority. They wanted to subpoena Stevie Repash, the director. And you're right, the zoning hearing can do that, but the requester has to identify the reason for the request. And then you can object based on the relevance. And then when the hearing is ongoing, that witness should have the right to know why they're there.
Exactly.
What's being asked of them.
So I think, without putting words in my mouth, just give us the reason why you're calling Ms. Heller. But I think that's the more obvious one of the four, which is why I'm starting with her. And then the board will just decide whether it's going to issue these subpoenas.
I mean, there are multiple reasons why we're asking.
Okay,
for
give us your best one because I on Ms. Heller, and then the board.
Right,
can
I think it
decide.
has to be specific, as I understand.
Yeah,
I
just
mean,
make it
the one
specific.
I've already mentioned is the fact that there was insufficient due diligence to study the impact of the subject amendment. Ms. Heller has drafted numerous memos that were interoffice communications, essentially saying that the impact of this amendment was unknown. Even with that representation, not only in written memos, and there are several of them, her testimony at the time before council indicated that there was essentially insufficient study of the impact of the amendment. Furthermore, there's an issue with respect to the ambiguity of the language of the amendment itself, in that it requires the combination of some commercial retail use in combination with a single family dwelling. This came up through the course of the hearings, and Mr. Preston produced his 8 properties that he felt may be affected by this particular zoning amendment. When he did that at the time of the hearing on November 20th of 2018, Chairman Waldron directed Darlene Heller to look at the 8 properties that were submitted and see if they were affected by this zoning amendment. She came back with a memo, I believe, dated December 3rd of 2018, indicating that none of the properties were affected, and defined single family dwelling as essentially a single family detached dwelling. However, where the confusion and the ambiguity comes in is in this in the city's zoning ordinance. It defines single family. It doesn't define single family dwelling. It actually has 3 different definitions that may qualify as a single family dwelling. And therein, there's a confusion and an inherent is an unconstitutional ambiguity in this, because what developed even at the passage of this act, the city planner had one interpretation of the zoning amendment.
You know what? We're going a little far for the legal argument, but you're saying she is the witness you would call on those issues, right?
And others.
And other ones.
You wanted me to hit the highlights.
You just need enough to get to, so the board understands if calling Ms. Heller is relevant.
No.
Fine with it, right? Yeah. Darlene's fine, right? Okay, all right, so I'll make a motion, and then the chairman's going to authorize the issuance of a subpoena on Darlene Heller in her role as planning director.
I'd like to accept a motion at this moment to authorize me to subpoena Ms. Heller.
Go ahead.
I'll make a motion to give you the authority to subpoena Ms. Heller.
Second.
Could you call the roll, Mr. Pfeiffer, please?
Certainly. Mr. Novatnik,
Yes.
Ms. Shea Gardner.
Yes.
Mr. Shantz.
Yes.
Okay, so you'll get that subpoena. The next one you requested was councilperson
Dr. Van Wert.
Dr. Van Wert. Correct? Okay.
Correct.
So can you explain why the board should issue that subpoena?
First off, Dr. Wert lives in close proximity to the subject property. She's less than a block away. She appeared at the Bethlehem Planning Commission meeting and voiced her objection to the amendment and set forth the various reasons that it was inconsistent with the comprehensive plan, that and a variety of reasons why she felt it was improper. I think that is important information that this zoning hearing board should hear. Beyond that, in her role as a city council person, and this aligns with the idea that the zoning amendment lacked sufficient due diligence and sufficient study to determine the impact of it. Dr. Van Wert, during the course of the city council meetings, and this was after the first vote, issued a subpoena, not a subpoena, a memo or an email request to Darlene Heller to produce essentially the raw data of the properties that may be affected under this amendment.
Okay, I'm sorry, can you go back?
Yeah.
You said that the first reason was that she lives less than a block from the property.
Right. And then
How's that
testified-
relevant to the validity challenge?
Because at the time that she spoke before the Bethlehem Planning Commission, she gave her list of objections to the zoning amendment.
Right, but she had her opportunity to do that there, right?
Right. It's information that would be relevant and for your consideration as far as the validity of the amendment.
What
Basically-
part of the validity? I mean, sorry, but you've lost me.
Right. One is that it's not consistent with the comprehensive plan. The comprehensive plan.
That's her opinion. It's just her opinion.
It's her opinion as
Are you calling-
also a trained city planner.
Are you
who's
calling
been-
her as an expert?
Yeah, that's what I'm.
Yeah, that's what I'm-
That's the question. So if it's for planning purposes, she's being called as an expert, because I don't think you subpoena an expert.
Correct.
That's
She will, talk about the various infirmities that she sees in
But
the statute.
here's my question with all that. Assume that that's what she's going to testify to. Where is it that we're in the case law, if you're looking back at the case law, that we should consider what someone said, again, as in the transcripts or anywhere else, at that prior proceeding that we've already decided, you may challenge it, but that we've already decided we're not going to admit in that, in the form of the transcripts. But if she's going to say the same thing, I get why you would want to bring her, but how is her opinion relevant?
Because it's going to elucidate to the zoning hearing board what the problems are with the zoning amendment. I mean, that's.
Can't we read that in the amendment?
No, because you need to take into consideration what impact this amendment has. And one of what Dr. Van Wert is saying is that more studies should be done. She was directly involved with making a request to Darlene Heller.
I understand that, but that's her opinion.
It's not an opinion, it's fact. She asked for fact. She asked
She-
for evidence as to what properties would be affected by this particular amendment. The city planner did in fact get some data on the
I'm
day of the
not-
last vote.
I'm not going to
and-
the merits of that. What I'm saying is, what is your purpose in our review and validity challenge to subpoena a member of city council? What is it you're trying to get out of her? What she thinks? What her opinion is?
What she think, when what the facts are that support or don't support whether or not this particular zoning amendment is valid, and she'll be able to point to where it violates the comprehensive plan.
That, in her opinion.
Where it's ambiguous. And
But we
where it's-
can't we get that information from Ms. Heller?
No, well, that's the problem, that you need to hear from the different witnesses who have different views. But obviously, Ms. Heller has a different view as
He's free to
far
bring
as
her.
And
the interpretation of the amendment.
Bring her as a witness.
yeah, that's what I said too.
But why do we need to issue a subpoena if she's going to be so favorable to, I mean, which is what I
Or
gather.
she has asked, no, respectfully, she has asked that a subpoena be issued just so it's official. So that she is under subpoena. She doesn't want to run amok. She wants to have an official subpoena.
We're going to take a moment and go into executive session.
Okay.
You're done.
Shutting it down. No, it's the transcript. Sorry.
I have to ask you. Funny you thinking you.
See you, Mel.
Before you start.
Who else in that list wants covered?
I know. Not a witness. You're asking. So, yeah, never tried. Question is, what point do you think she will be on?
I didn't know if that's what they just said right there.
Well, they're gonna let us.
I can ask, just because I'll tell them, you have to get home to your kids.
Yeah, I didn't think it was gonna be as long.
No, I appreciate it.
So, I just didn't know if you needed it. I mean, because I want to help out.
Let me ask, when they come in, I'll say, you have sort of, you can come back the next day, like
Next time,
the next time.
because she'd be going on kind of. Let her on.
No, not necessarily.
I wasn't sure if they just say too, if that was stricken, if they don't want to even say what was brought up that night. Like,
Not necessarily, I can introduce it, so we're just gonna take it this way.
Yeah, but her testimony is about neighborhood. And which is the essence of.
Sorry? Yes, and you can have your friends and family tune in now.
Always mortified me to lose my sleep in
You got all night. Okay. This retreat. I know that.
Are you ready to go back on the record? Just for the sake of the audience, we would like to go back on the record at this moment after concluding an executive session where we've wanted to consult with counsel.
Make a motion that Dr. Van Wert's, the request for Dr. Van Wert to be issued a subpoena is denied.
Second?
Mr. Pfeiffer, can you call the roll, please?
Mr. Novatnik,
Yes.
Ms. Shea Gardner.
Yes.
Mr. Shantz.
Yes.
Okay, then the last two are the same. They're two members of the planning commission, correct?
Correct.
Okay, so can you give us if you need to give us separate reasons or give us one reason for the two?
Well, Matt Malozzi, as we know, is a trained engineer. He
Okay.
voted no for this amendment, and he would provide his reasons why he feels the amendment should not have been passed, because it goes to this issue of there was insufficient study. He didn't know what the ultimate impact would be. Plus, he didn't feel it was consistent with the comprehensive plan. Similarly, Joe Cohen voted no and had similar concerns.
So are you calling Mr. Malozzi as an expert witness, as an engineer?
No, it's really factual. He's going to establish.
But is he an expert witness in your opinion? The reason you just gave us was that you're calling Mr. Malozzi is that he's an engineer and he's using his engineering background and expertise to give his reasoning as to why he voted against this. So one would conclude, based on what you just said, that he's an expert witness under these circumstances. That
Yeah, I mean, he's going to give his view of this amendment and what his thought process was at the time he voted no, at the time of the hearing.
Okay.
I think that's relevant for your consideration, what his thought process was.
Were there, can I ask a question? Were there other members of the planning commission that voted on that? So when you're saying they voted no, were there people who voted yes?
There were people who voted yes, and they didn't say that's one of the issues. They didn't give a reason. They voted yes for the amendment, but I don't want to.
No,
The transcripts speak for themselves, but they gave little, if any, reason for their yes vote.
Right. And I'm only
However-
asking because you're only subpoenaing the two. I mean, and I understand you're making a case, but I'm just trying to flesh out that there are other members of planning commission also, and wondering how that impacts that. Okay.
Can I just ask a question then? I
yeah.
guess my question becomes, how is that any different than how we just ruled on Dr. Van Wert?
In other words, should you just call them as witnesses because you're calling them as witnesses in your case in chief? I guess that's the question we have.
I just, because they serve the role as a public official, I want to follow the procedure and make sure we have subpoenas issued. I don't want to be in a position where, okay, then I go to Mr. Malozzi and says, I can't testify, we need a subpoena. I'm a member of council. I don't want to run into a problem there. That's why I'm asking this board to issue the subpoenas, so we don't have to come back for subpoenas or have to revisit this issue.
Have you asked them, either of them, if they would testify voluntarily?
I have not, because the hope actually was that the transcripts would be submitted.
Gotcha. Yeah, I mean,
Those statements would be accepted. That was what
right.
their view was at the time.
It wasn't a loaded question. I was just asking.
And we wouldn't have to go through this process. But if we want.
Yeah.
Do you guys want to comment at all on this one, or is it just back to, if we issue it, you'll preserve your objections and it's up to the board? Whatever. I don't want to put words in your mouth.
Right. I suppose the only thing I would say is that, I would hate to kind of I know these are people who would testify on Mr. Stevens' side of the case, essentially, but still they're being subpoenaed. So we're ordering people to come to the next proceeding here, where I will be obviously raising these same objections to their testimony that I raised to the introduction of the transcripts. These are planning commission members, so people who weren't even voting on the ordinance, which is what's being challenged here tonight. So I think it's unreasonable harassment of people, given the purpose for which they're being asked to testify. But that's kind of my cautionary bit there.
Can I just say, I think the planning commission is a commission, just like city council is a council, and they take a vote and they issue a decision. We have the decision of the planning commission, and we have the decision of the city council. Seems like what we're going to try to do now is going to parse that, take that apart, try to understand why, who did what, who shot John. I don't know that that's, we know what the planning commission voted. We have their official vote.
And my response to that is, you have a vote. I mean, the purpose of calling them as witnesses is to give them your rationale, to bring them in here and say, okay, Mr. Malozzi, why did you vote against this? Tell us, and give us some insight as to why maybe we should strike this amendment as being invalid.
Well, the same argument can be raised. Why not call all the two members who voted for it and ask them why they voted for it?
But they certainly would have that right to do that if they want to call the people who voted for it.
And then this board has to decide whether the planning commission made the right decision or not.
This board would have further insights as to what the basis of the challenge is by virtue of other people who have studied the amendment and come at it from their various areas of training and expertise.
So are we experts again now? I'm.
No, I mean, I think the point is, are you just going to decide this in a vacuum? Okay, we're going to throw out the transcripts. We're going to.
Well, we decided that now,
We're
so
not going to, we're not going to hear from any witnesses.
we never said we weren't going to hear from witnesses. We've said we will listen to witnesses. Obviously, they have to meet the standards for admissibility of the witnesses, but that doesn't mean that, we're not going to take this seriously and look at everything that is presented to us. But I guess I'm not even sure what the relevance is of the planning decision. We know what they decided. You're asking us to get in their heads again, which you've even had said they didn't tell you on the record why they were doing that. They just said yes or no. So I'm really struck about how that is going to help
They
us.
did tell us on the record exactly
Mike,
what their basis was for voting no. And as I just repeated, Mr. Malozzi said there was a lack of due diligence and study. He had no idea what the impact would be. It was irresponsible to pass this amendment, and therefore he voted no. I think that's important information that this board should hear in making their determination. And as I said before, Ms. Cohen had a similar response. So it wasn't just a vote yes or no. They gave their reasoning and an explanation that is helpful and would help guide this board.
But they're different than we are. They're a commission, right? We're a hearing board.
But this hearing board needs evidence. They need to
You
hear
can bring your
testimony.
evidence in.
They need to review documents that would be
Let go, Tom.
instructive.
So does the board want to vote on this one now, or do you want to continue with the hearing and at least allow him to renew his subpoena request when we kind of understand things more?
Yes.
Okay, so we're not, those are not denied, Mr. Stevens. It's just, I think we are so far down the road as to what the case is without having any evidence yet before us, only because we've had to hear some of these arguments to frame the case. I think the next thing would be, let's start with, we'll move on and move forward. And then when the board gets its feet wet on the case, you can renew that.
Yeah, we'll table the motions right now for the subpoenas for the other two hearing members until after we hear from Ms. Heller.
I don't know. Can I ask a question?
Yeah.
Okay.
Yes, me.
Go ahead.
Let me ask you that.
Yeah.
Mr. Haynes just wanted clarification on the ruling to not issue the subpoena for Paige. If she voluntarily comes forward.
Not a problem.
You're fine. with
Yeah,
that?
that's what we're saying. We're not trying to prevent anyone from
No.
bringing in the witnesses, but our question is, we just didn't think we should be put in the position of subpoenaing her just because I'd prefer I be subpoenaed even to come testify for you, right?
Yeah, of course.
So-
Attorney Stevens, this board has a long history of allowing basically anybody that wanted to testify before it. We've never, with one exception, we have never actually told a witness that comes before this board that they cannot ask a question of this board or testify before this board.
Relevant
welcome.
question.
We welcome.
Relevant. Yeah. I mean, she'll be subject to the same objections on the relevancy, but absolutely, you can call her. Not a problem.
And I totally respect that. And
Yeah.
the reason, as I said before,
I
there was a
know.
request by Paige to have an official subpoena. I was sort of assuming the other public officials may be in that same boat and would want subpoenas, and that's why.
She considers herself.
And
She thinks she needs it. Listen, if you say that, she's a public.
Okay. All right.
Okay.
So I think where we are now is the subpoenas of the planning commission members are under advisement because the board would, for example, to the extent it relates to planning testimony, that I think hearing Ms. Heller's testimony as a witness of yours will help us then understand a bit better those concerns, and we can re-rule on the subpoenas, but you are welcome to call them as your witnesses too. I mean, again, that doesn't prevent you, but we'll rule on the subpoenas. The board will rule on the subpoenas at that later time. So I think that brings us to
Swearing witnesses.
the end of the procedural issues that I'm aware of. Or is there anything else at this time?
I would just say.
Yeah.
I did bring with me because I wasn't, I'm sorry.
Oh, yeah.
I did bring with me because I wasn't sure if anyone else would have them, certified copies of the actual ordinance signed by the mayor, one set, and then another set with the conform signature so you can see who actually signed the documents. I thought that might benefit
Okay.
the board if we could introduce that. I presume no one would have a problem with that.
Any objection?
I have no objection.
Okay.
I've copies for
Okay.
everyone.
So were we going to mark those city 1 and 2?
That's fine with me.
Okay. So city 1 and 2 will be admitted.
I forgot we have a stenographer up there. I was writing it myself.
That's okay. Eric usually does.
Yeah, we can do it. So. The exhibit, is that 1 and 2? This 1.
This could be 2. I'm giving you the raised seal, so that's city exhibit 1, and that's.
This is 2?
This is
Okay. Okay, so then we'll just put, the board doesn't just think C1, C2 on that.
I guess since he's admitting a piece of evidence, the zoning amendment, if there's any exhibits on my witness list that we could stipulate to, just to move things along, particularly the memos drafted by Darlene Heller, because there may be references to them as we proceed with my witnesses.
I thought there was no stipulation that
Well, this is, he's not,
Yeah, he's
there's
not.
not a stipulation on the transcripts. He's just
on
asking
that.
if it makes sense. Pardon me? You haven't looked through those? Okay. All right.
So none of the memos of Darlene Heller.
I'm not objecting to them. I'm just not waiting like that. I guess when Darlene comes, if you want to,
Right.
if you want to afford me an opportunity to look at them, I could.
I suppose the only thing I would just do to streamline it, I mean, if the purpose is just a notice purpose, then I presume that I trust Mr. Stevens is introducing authentic memos. But if the purpose is to offer the content of those memos for their truth, then I would have an objection without Ms. Heller being here.
We're fine.
I think we can wait. For those. Yeah. And for the record, Ms. Heller was unavailable tonight, so we knew this was going to happen in terms of her unavailability. All right.
Get through 1 or 2. Attorney Stevens, how many witnesses do you have, were you prepared to call this evening?
Tonight, I mean, I had on deck, I believe, 7 total witnesses, one of which has some childcare responsibilities. Ms. Wilson, but that's.
Well, that's the board probably should we do at least a couple of witnesses?
Okay.
I mean, 2.5 hours, but I don't know what time you want to go till tonight.
Yeah, I know.
You want to go 9:30? It's been a long night. Yeah, okay.
At this point, Ms. Genova, can we actually swear the audience in at this point? For those that are planning,
Anyone might testify, right?
yeah. For Attorney Stevens, since you're planning on calling your 7 witnesses, how about those witnesses that you would like to call that you feel that you can get through in the next hour?
Well, why don't we swear? Could we swear them all?
That's
Just swear
fine.
'em all in.
Just swear them all in.
Yeah, and then they could come back.
Yeah.
Okay.
Could they all rise for anybody that's going to be
Should I-
testifying or questioning? At this point, I would ask you everybody to rise at this point to be sworn in.
Raise your right hands, please. Do you swear by mighty God, the
Gallagher.
searcher of all hearts, that the testimony that you shall give in this proceeding should be the truth, the whole truth, and nothing but the truth, and as you shall answer to God at the last great day? Do you so swear?
I do.
Attorney Stevens, you're free to proceed with your first witness.
Wait, wait. First witness is Ms. Wilson.
Okay. Before we get started, is everyone, just to double check, because it's been a while since the hearing started without us going anywhere witness-wise, and that is, if you're going to speak, I want to make sure you sign the list that's up there and you put your address on it.
Yes.
Okay. So if you haven't and you think you might, please sign. Otherwise, and still say your name and address when you get up to the podium also.
Sure.
That's very helpful.
Okay. So
State your full name for the zoning hearing board.
it's Mary Rose Wilson,
And what is your address?
64 East Wall Street,
How
Bethlehem.
long have you lived at that address?
Over 10 years.
And who do you live there with?
I live there with my husband, Patrick, and my 3 children, one of whom is in college right now, and the other 2 at home. My 3 kids are Liam, Declan, and Kiva.
Did you testify at the city council meeting on December 4th of 2018?
I did.
And at that time, did you relate to city council the constant battle to fight off commercial intrusion into the residential neighborhood that you live in?
I did.
Can you please expand on that with the zoning hearing board and tie it into as to why you think that impacts this amendment that's before them?
Basically, yes. To summation, what I said that evening is that, we are a residential neighborhood. And I feel like we are constantly having to battle between the illegal Airbnbs that are operating in our neighborhood, that are operating as basically just hotels. And now with this property that's being spot zoned, that,
Objection. Legal conclusion. Okay.
Okay. It's noted.
but anyway, to go on, it feels as if we are constantly embattled when it's like, when you live in a residential neighborhood, you have an expectation as a resident that it will stay residential, that you're not battling businesses coming in next door. And if there's really no rules, it's, what's to stop? My husband has an online retail business. Why couldn't he just put a shutter outside our door and not go through any proper channels and just start our own business? It's like, it just seems that the rules don't seem to apply to certain people when you look at what's been going on in the neighborhood. And so it has been a battle that we want to try to keep it residential. I feel like if we lived in a little, suburban cul-de-sac community, you're not going to have a bar pop up next door or a hotel or a financial office. But it seems like because we live in town, oh, well, it's just expected. It's like, well, I understand that we live in a city and we are close by to business districts. We have Main Street, we have Broad Street, and they're wonderful. I love going down to Main Street, for dinner and stuff. But in our neighborhood, it's a neighborhood. It is a residential neighborhood. We raise our kids there. We take care of our neighbors. You mow lawns. I know that sounds also like, I'm talking about, some idyllic world here, but that's why we moved to Bethlehem, and we love to have neighbors. We love to live in a walkable town, but we should have the expectation that a business isn't going to pop up right next door.
Now, you're familiar with this location at 2 West Market Street.
Yes.
I believe you testified before city council that you had concerns that with this passage of this act, that the neighborhood is just going to become this extension of the commercial, Broad and Main Street areas. Can you explain that in more detail?
Yes. I mean, if it starts on that corner and then it goes into another corner, and basically what it'll set up is if 2 West Market can operate, the Dr. and Sir properties, they're just going to keep operating. And that's right now, is according to the state Supreme Court, is not supposed to be happening, but that's a whole other thing. But it becomes, at what point does it start? Well, this person gets a pass. Well, then this person, they got a pass too. And then all of a sudden it's just every corner there's a business in our neighborhood. And that's not why I moved to historic Bethlehem. I lived in Manhattan, I lived in London, I've lived in places where there's businesses everywhere. That's not why I moved to Bethlehem in this particular neighborhood. And so that is a concern because it seems like there has to be some sort of zoning restrictions. And if there's no zoning restrictions, then, all of this is just pointless. So.
I think you also testified that you had concerns that this influx of businesses.
I do. I object to the leading nature of the question.
I agree.
I mean, I guess I do understand that, but if she did testify to that subject before, I think it'd be fair to say that you testify about X, right? So we'll probably get to the same place at the end for now.
Yeah, that's
Okay.
fine.
Okay. You can finish the question, Mr. Stevens.
Do you recall testifying the concern that businesses like what's happening at 2 West Market Street will chase the residents out of your residential neighborhood?
Eventually, yeah, I do worry about that. And it becomes, if it becomes just a sea of financial offices or law offices, all the charm that's in that neighborhood is just going to slowly start to disappear. I mean, there's already been issues with the Airbnbs and people complaining about the all-night parties going on. And that's not really a great place to raise a family if you've got small children. You don't want, all-night parties next door, nor do you want to have to lose families to offices that close at 5 o'clock. And then you have these big empty buildings there. That's not a neighborhood. That's not a residential neighborhood. So that is a concern.
And then have you had an opportunity to review what you testified to at City Council?
I did.
And is that statement a true and correct copy of what you said at City Council?
It is.
I'd like to introduce our appellant's exhibit.
Give a copy to the other council first, please,
Sure.
and
That's 29.
Talking to the mic.
We only go to 28.
I have the transcripts marked.
Oh, they're not part of, you didn't put those in here?
I mentioned them when I was talking about the issue with the transcripts.
they're listed in 24, but you didn't give us copies of those yet. Because the reason you hadn't is because we were ruling as to whether we were gonna take copies, right?
Right.
Okay,
I want to keep them. I want to keep them marked as the exhibits. I mentioned
Right.
each transcript to create our record.
right, and you can, those would be part of the record of tonight, but not admitted as exhibits.
Right. So just so we're clear, should I hand these up now? I mean, I could just hand up one book just so we
Yeah.
can have them in the record.
Yeah, just put it there. We're not gonna.
For as exhibit 29.
Okay, so the 4 transcripts that you reference in your letter of September 3 are 25, 26, 27, and 28. Is that right?
25, 26, 27, and 28.
Okay. And I'm marking that.
Yeah, there's pages of transcript here. It's kind of, I don't know how we're going to cross-examine on that. I don't necessarily have an objection to this coming in, provided that this witness remains available at a later date after we read this, because we don't know what's in here.
Okay. All right.
I don't have that.
Okay. So
This plan is now 29. 26, 27, and 28.
29, that you just brought up
I know
29.
29 is
It's just that.
It's just this,
Okay.
it's just the portion that this witness adopted. Okay, so just give us a sec, give me a second to get organized here. So Exhibit 29 is the transcription of MRW testimony. Do we have a date?
I'm going to assume December 4th. Yeah, Tuesday, December 4th. The council, Bethlehem City Council.
12/24/18.
Yeah.
City council meeting?
Yes.
Oh, we're marking this as 20.
Okay, all right. We should hand them all to them now. so that we doesn't- Okay, all right, good point. Council, Board Member Gardner makes a good point, which is, Mr. Stevens, if you're going to be doing this with other witnesses, can we mark those now, hand them out to everybody so that we can read them and council can read them so that we don't have to keep calling witnesses back? Does that make sense?
We need to look at it.
Right.
Right.
Okay.
In other words, the next time, rather than continuing to do this and having to recall and impose on people,
Okay.
that we would, now you have them, right? So if you have them now, then you can prepare for the cross-examination the
He
next
wants
time.
to identify.
If identify which
Right.
ones
I don't
he's
wanna
doing.
have to read
So,
all
so, so let's finish with this witness. And then at the end of this witness, could you please just identify the rest of the people you'll be calling that you would similarly be asking for them to adopt their testimony so they can just read it in advance, and then we won't have to call people back. Does that make sense?
The next.
But-
You want me to do that now?
Well, finish with this witness with Ms. Wilson so we don't hold her up. Wilson, correct?
Yes.
Yeah.
Thank you.
I have nothing further.
Oh, okay. All right. So right now, let's say you had the six people here and 3 people that couldn't come tonight. Identify those people, whatever number that is, just so if there's anyone we don't get to, next time they won't have to be available as a third time, right? Because council will be, we will say, council, you will agree to review these in advance. And because we're not going to delay that if you didn't read them. Correct?
Yes.
Yes.
So that, Attorney Stevens, you were talking about, the economy, judicial economy, or economy of the time spent with the board. Wouldn't that be more productive to give them an opportunity to do that and then come back so that they know what was in those proposed exhibits, transcripts, et cetera? Then they can, because I don't even know how they can verify the accuracy of anything at this point.
Right. I just respectfully, I just want to place it on the record too. I did share those transcripts with opposing counsel at the same time that I made the request to
Right.
have this transcript submitted. So electronically, they were sent those transcripts with all these
Right,
witnesses.
right. Except we didn't know that those transcripts in toto, you offered them for that purpose. We ruled on that. The council is saying they don't have an issue with you doing it by bringing the witness in. But in all fairness, I did not read them until you gave me your explanation tonight. I mean, it was 4 large documents, and I don't know that the city zoning board wanted to pay me to read those before they knew I had to read them. So I'm
Correct.
not
I
trying to
just
be
wanna place
cute.
that on the record. I mean, that they
Fair-
were provided these
fair
transcripts in
enough.
advance. It's not as if they're seeing these transcripts for the first time.
Right.
So the list of witnesses for tonight, Ed Gallagher,
Okay, I'm sorry. Go ahead.
Frank Mayberry.
Can you stop? I'm sorry. I was listening to a board member. So Ms.
Ed
Wilson,
Gallagher.
who's the next one?
We just had
Right.
Mary Rose Wilson, Ed Gallagher,
Okay.
Frank Mayberry,
Frank Mayberry,
Bruce Haynes,
Bruce Haynes.
Beal Fowler,
Okay. Beal Fowler.
Robert Romerl,
Okay.
maybe Martin Romerl if he's
Okay.
not here yet. Maybe he's got work, but said he would come after
Okay.
work. and George Rummerall.
George, okay.
Got ones for next time, I think. It's for everybody.
Do you want the rest for?
Yes.
That's for tonight. Those are.
Okay, that's yeah, if we get to them, that's tonight. Keep going though with anybody else
Okay.
that might be
The-
here.
The
next
others
time.
on our witness list are Mary Toulouse.
Do you spell Toulouse?
Toulouse.
Okay,
Ron Yoshida, Yoshida.
okay,
Stephen Antalix.
okay.
But I have a question with regard to, does he live on the south side?
He does, yeah, and he testified at almost, I think, every proceeding for this.
Although this is, I mean, I guess we would have to consider this is an amendment. This isn't.
Okay. I withdraw, I
Yeah,
apologize.
so no. I'm just saying, we need to consider that fact in this proceeding. It's hard to kind of separate it, but okay, go ahead.
Virginia Fowler,
Virginia Fowler, okay.
Bill Shire,
Bill Shire,
Karen Beck Pooley.
Beck hyphen Pooley,
I think it is.
Okay.
Pooley.
got it.
Cheryl Dugan,
Cheryl Dugan,
Barbara Diamond,
Barbara,
and Stephen Diamond.
okay.
Yeah, he's here. So.
I just have one question, Attorney Stevens, and it's with regard to something I had mentioned during the earlier part of the night. Normally, repetitive testimony, we have the right to reserve or to cut repetitive testimony. Are all these witnesses going to be basically testifying to the same thing, that they don't want to see the degradation in the neighborhood, or?
No, I mean, that's certainly one of the themes of the neighbors, but each one has certain areas. There's bound to be some overlap. I mean, they're,
Okay.
neighbors and interested parties. But we're working to focus on, areas of testimony.
And they're all expert witnesses, or they're all just neighbors?
They're all fact witnesses, correct?
Oh, and the other is Alan Loucher is the other.
Okay.
Yeah, and so both Karen Beck Pooley is an expert and Alan Loucher are experts.
Okay, my next question is, do you have individual ones for each of them now?
Yes.
Okay. So is the board, is it easier for him to hand out all of these individuals? Or because we haven't admitted the whole packet, I think that's the way, in other words, we're not admitting the transcripts in total, right? So I think we almost have to have these individual ones handed out, because the board shouldn't be looking at the balance of that exhibit. And they should be looking at this vis-a-vis, for each witness, correct?
As it
Correct?
comes up.
As it comes, well, except we should be getting these. If there's a witness that he's not calling, it's not admitted because it's part of the big transcript, the overall transcript. So we can't, I don't believe we should be handing the board the full transcript.
Right.
We should have these, okay?
As they go along.
As we would get them as they go along, but council needs them, probably doesn't, you've seen the whole transcript. My question is, are you just going to look at them in the whole transcript because you've got that whole transcript?
We're not going to, I'll speak for myself. I'm not going to go home tonight and read this thing.
Right.
That's not going to happen. Now,
Right.
Mr. Stevens wants to call a witness and supplement that witness's testimony with a document.
Yeah.
I don't have an objection to that because the witness is here.
Yeah.
That's what we originally objected to.
Right.
But I should be told which pages are going to be coming out of here.
Yeah,
I can-
but if he has them all, why don't we just hand you the pages, is my point.
I don't have a problem with that.
Okay,
Yeah, I mean, and quite frankly, they're indexes. So like you go to the name of the witness and you can find them in the transcript quite.
but do you
If
have
you want-
copies of them individually?
I do.
Well, why don't we just hand them out? I mean, it solves the
To
problem,
that,
right?
yeah.
You want to do that now?
Yeah,
I mean, because
yeah,
I'll go.
let's
through
do that
them
now.
and mark them.
Yep.
All right. So
Are we going to finish with this witness?
He said we're done.
Okay.
But does
Okay,
council?
so you're up. Yeah, so,
what's that?
yeah, so if they're gonna cross-examine, let's finish her cross-examination.
Okay.
And then we can do that.
Ms. Wilson,
Yes.
guess you said you spoke at the city council meeting on December 4th. Is that
Yes.
correct?
That's correct.
And I think you testified that you were concerned about the I guess coming to Bethlehem or coming to your neighborhood of bars, salons, and party houses. Is that correct?
Same with you. Yes, my concern was that if you make an exception for one thing, when you just, you can make an exception for all, or there's no exceptions, it can be anybody then. So it's kind of basically my concern is, where's the stipulation? Is it a financial office versus a restaurant or a salon or whatever? Like, what determines what business would be allowed or not allowed?
Are you aware that the zoning ordinance amendment does not permit restaurants or salons or hookah lounges?
Well, it doesn't seem like the zoning laws mount for much of anything because it seems like you can get them changed.
Have you read the zoning ordinance amendment that was actually enacted by City Council on December 4th? Have you read that?
No, not in its entirety.
What parts of it have you read?
Parts concerning this, I guess, but yeah.
What
I
about-
actually have read the zoning laws about that we are supposed to be residential, but when you look at the fact that he's supposed to be actually living in that building and he's not living there.
What parts of the zoning ordinance amendment that was enacted by council on December 4th of last year have you read?
I don't recall.
Just on my objection, it was not enacted on December 4th. It was passed on December 18th.
December 18th.
Sorry, I don't recall offhand, but I am aware of the zoning ordinance.
Your particular property on East Wall Street,
Yes.
is there any commercial use on that property?
No.
Is it on-
Well, if you count working from home, but there's no commercial use, there's no commercial business.
is it on a corner?
No.
That's all I have.
I have no questions.
Okay.
I turn it over to the board then. Any questions of the witness?
So is your concern this particular amendment causing degradation of the neighborhood? Or are you concerned about council will now find it free and easy to make all kind of amendments?
That would be more of my concern, that it'd be free and easy, because this one, because it had been appealed from my understanding in court, and he had been shot down and then appealed to council. A council then
But your
subsequently.
concern is more, what may come down the
Yeah,
road?
exactly. Is there a stopgap now? The solicitor says that the zoning rules are in place, that, we're not going to get bars and salons and, businesses like that. But at what point will that change? I guess that's our fear, because if, what are the rules? Because if the rules can be easily bent and changed based on who's in city council, it's a little unnerving for us as a residential neighborhood to wonder what's going to happen in the future.
Right, thank you.
Commissioner Gardner?
I've nothing.
At this point, I would turn it over to the audience if anybody has any questions of the witness. Seeing none. Oh. Come to the microphone, please, ma'am, and state your name and address.
My name's Suzanne Virgilio. I live at the corner of New and Market, directly across the street from the property in question.
Did you sign the sheet?
I did.
Thank you.
My question is to the witness. I understand where your location is in the historic district, perhaps would be residential. But if you take into consideration the location of the property, the intersection is a commercial intersection in front of my own home. I have a Lanta bus stop, which is not residential. I mean, you don't have a Lanta bus stop in front of your house, do you?
Objection.
I mean, I'm just saying, yes, we are all within the historic
Hold on,
district.
Hold
Only
on, one at a
okay.
time, please. One
Yeah.
at a time.
Just hold on. Let him finish his reason for his objection, and then we'll go from there. Thanks.
We're all within the historic
Uh,
district.
uh,
I'm sorry.
It's argumentative. She's getting into repeated questions.
Well, okay. Well, let's just do this. Do you have a Lanta bus stop in front of your house? Okay.
So the personality of the historic district is different from block to block.
Is that
And so,
you have to ask a question? Did you
Oh, I
ask
have to
her
ask
the
you a question.
question? Does
So-
she- yeah.
okay, I purchased my property with the intent of opening a bed and breakfast. If my intention were to buy a house, to raise a family, to borrow a cup of sugar, to mow my lawn, and so on and so forth, I wouldn't have purchased a property there. Would you have purchased a property there to raise your children at the corner of New and Market?
Actually, we looked at your property to buy.
But you didn't buy it. It
It was too expensive.
was too expensive. Okay.
at the time.
Okay.
But, I don't think there's a reason for animosity. I'm just saying you actually live on your property, correct? You
I
live in
do.
the business that you operate.
I do.
Mr. Reach doesn't live in the
Mhm.
building that he operates his business out of. That's the problem.
Okay.
And the same is with the Airbnbs. As I'm
But this is not the Airbnb.
But I'm
Like,
saying. this is-
Hold on.
objection, she didn't finish her response
Yeah.
and was cut off.
You have to let her finish her
I'm
answer,
sorry.
okay?
Not really up on protocol for
No
this.
problem.
So it's the problem I'm having is when people are starting to operate businesses and in this case.
Excuse me, I hate to interrupt, but we can't hear you.
I know.
You need to share the mic.
It's not,
Back to the mic.
she should be questioned by Attorney Stevens again, right? Not having a conversation.
Well, I think Ms. Virgilio needs to ask a question.
Yeah.
Okay, and what was that question? Because I'm not sure we were getting that
Question
answer.
was, if you were looking to purchase residential property in downtown Bethlehem, would you look at the intersection of New and Market to
Okay.
make that purchase as a resident to raise your family?
Okay, and can you answer that question?
But no, my objection to it, she's answered that. She looked at that house and.
Okay.
And
Oh,
testified
okay.
that it
So
was
she did answer that
expensive.
one.
So that's.
We
30
looked at-
years ago, you looked at our house?
No, we looked at it when our realtor showed it, Barbara Frost.
Okay.
So,
Okay.
and that was about 11 years ago.
Okay,
Um,
all right. Just to,
but that's,
well,
point
that's a complete answer to that question. Next question, if you have one.
Um, Do you really think it's fair to confuse Airbnbs with this particular property because they're two completely different scenarios?
my concern is because there is nothing being done about the Airbnbs, even though he's in complete violation of the ordinance that was passed. And then when you look at what's happening here, where a specific ordinance was created, which was pretty much just benefits this one property. It has nothing to do with your property, it has to do with that property. And when you see that as a resident, and you see that all of a sudden it doesn't seem like zoning is really working in favor for what necessarily the people want that live in that neighborhood. That's my
I
concern.
have no other questions.
You can follow up, Attorney Stevens.
Ms. Wilson, you mentioned that you looked at the subject property with your family to live there, correct?
Yes.
And were you interested in also living there full-time and running businesses
No.
as well? So you
No,
would have.
we would have converted it to a single family home.
Okay.
That's Ms. Virgilio's property, correct?
And there's been testimony in the underlying proceeding that this property is absolutely, it's not suitable for a family. There's no yard. Did that not apply to you?
Well, I'm sorry, repeat the question.
There's been testimony that this subject property is not at all suitable for a family because it doesn't have a yard and it's right there in a busy intersection.
Honestly, I think that property was great. So the Second West Market. Again, we already had our house on Wall Street. We actually had told friends of ours that were looking, because they were living on West Bethlehem, we told them to look at it when it was for sale because you could rent apartments in the back. And I thought that would be a nice way to make income to put towards your mortgage. I think that could be a stunning home. And when you look at the $2 million homes that just sold on New Street, I mean, there's a market there. And then somebody just converted the B&B, the Morningstar B&B, into a single family home. There are people that have a desire to get these big old homes and turn them into single family homes. They're not just these, big monstrosities that nobody wants to deal with. So I think there's plenty of people that have turned places. Like, look where Paige, she's right on, she's in the thick of things on East, or I guess it's, I don't know, it's East Market at that point. There's, a lot of houses that are close to it, but I just feel like if there was already ordinances in place and some people are grandfathered in, that's fine, that it is what it is. But start opening up the can of worms of now opening up to other properties, there is a concern about where will it stop.
And was this particular property somewhat of an attraction because it did have rental properties and you could help with your mortgage that way.
Well, Second West Market, we
you know
didn't
what?
actually
That's
look at
kinda-
it.
That objection sustained. That's leave it.
Well, and also to say, we didn't actually look at Second West Market Street. Like I said, we had already purchased our house. I just thought it was a beautiful property, and we would hope that, somebody would buy. And I will say, Mr. Rich has done a beautiful job restoring the outside of that property. It is beautiful. My concerns, if there's rules or there's ordinances or there's laws, if they can be so fluid, then I feel like you can open up floodgates.
Nothing
Another
further.
question.
Okay.
Are you aware that at the beginning of this whole scenario that myself and another neighbor went door to door throughout the entire historic district and had over 100 signatures long before all of this supporting 2 West Market being used as it is now, including Patreon where its husband signed it?
Objection, the
Oh.
question's irrelevant because the petition that she's referring to, I think, involved another
Yeah.
zoning proposal. It doesn't pertain to this
We'll
particular
sustain that
matter.
objection.
Rich's proposal.
We'll sustain that objection.
Thank you.
All right.
Can I just add one more question? Because just so I'm clear, your concern is not that this particular ordinance will allow single-family homes to be converted into offices, but that this ordinance will then be the leading edge of additional ordinances that will allow them to be converted. Is that what your
Well,
objection
I
is?
mean, I would think that this being a corner property, if it would start applying to other corner properties, if it could be used as a precedent for, well, this is why we want to do this on another corner property, but I do worry that it could lead to further ordinances.
Okay, but you understand that the ordinance is more than just a corner property. It requires other,
It's mixed use, I believe.
okay. And there's not too many of those around where you live, is there?
No, but again, there is that concern as well that it could lead to, if you can change it for this property, if somebody else. is
Okay,
like, well,
I thought that's what you were
Objection,
saying.
he cut her, she was still in the process of giving her response.
You can
He
finish
cut her
your
off.
response.
No, I'm done. It's just, again, it's the
I'm
concern
done as
with
well.
the-
Thank you.
Any going once, going twice? Thank you very much, Ms. Wilson.
You're welcome. Thank you very much.
Thank you. Attorney Stevens, your next witness?
My next witness is Bruce Haynes.
Okay. Do you want to hand out though?
Yep.
Like that. And then we'll end at 25.
Have your-
Give
have your
you time to hand out. So I think the board is going to go to 9:25, and then the last 5 minutes you can mark those exhibits, and so we've got the exhibit numbers, and then hand them to council.
So I assume Mr. Haynes again will be.
Yeah,
remain
Mr.
available.
Haynes will have to come back.
Yeah.
I'm sure he'll be glad.
I'll come
to.
back, you said?
Yeah.
Oh, so we're not gonna,
No. If they want to read your testimony that
Oh.
Mr. Stevens wants to put in, they're asking that you remain available to cross-examine on that because they're not going to have the chance to read it tonight.
next time, yeah, no
Yeah.
problem. Yeah.
Which was why I suggested that needs to happen so we don't have to keep bringing
Right.
people back.
Right. And I think we'll probably end with Mr.
Yeah.
Haynes
Yeah.
and we'll have that problem solved for everybody
Right.
else.
Or we just pass all of them out and then we all come back at the next hearing.
That's what we're going to do. But you're
Instead
here.
of keep going tonight, just
Wow.
all come back. I mean, it is.
What do you guys want to do? Start
He's
with
not
Bruce.
buying us dinner, so.
Well, I can't imagine.
Hold on. What? Right. Okay. All right. I think that's what we'll do because we're expecting that you'll be maybe a little longer. So
Me?
yeah,
You're gonna go with me tonight? eh?
there's some history. So
It wasn't personal, Bruce.
No, it's nothing. But your testimony might be longer, Mr. Hayes. So good suggestion. We'll take that. So why don't we do that, Mr.
No
Stevens,
problem.
down before we leave? So you can step down.
Oh, you're not gonna,
No, we won't start with you. Let's just mark these and then they'll have the benefit of everyone's testimony for next time.
Oh, so you just want to mark exhibits? then
Yep,
we're gonna-
and
that'll
get
take
get
us
those
to
numbers
9:25.
done and do that. Because all we're saying is, Mr. Haynes, we're guessing is a primary witness of yours. So,
And Mr. Schock, thank you. I got to concede, this is very confusing.
so,
I now have two transcripts here, multiple pages. I don't know what.
right. So
And that's because I testified at the hearing and I testified at the city council.
Right. So that's why I want to get organized on that so that we don't. So you can go ahead. You don't have to stay up there, Mr. Haynes.
Okay.
Okay.
Well, what about my exhibit that we want to put in?
We'll do that when you testify.
When you testify,
Oh, You're gonna-
exactly.
we're gonna bring you
All
back.
we're doing is the transcript exhibits.
Each person's going to stand up and you're going to have the transcripts and that's it.
No, I thought we were going
We're
to
just marking exhibits.
Just hand them out. You don't even have to stand up.
Got it.
Not to us, but to
That's
council.
okay. So, but let's at least get the numbers down
Correct.
so that the zoning officer can get that record too. So let's just take the time now. So you ready? Okay. So Mary Rose Wilson was A29. Okay. What is Mr. Haynes? Is he multiple ones because you marked each date individually?
Yeah, it's one exhibit for Mr. Haynes,
Okay.
Exhibit 30, and it has the two dates that he testified to, and you have the exhibit. It's the
Okay.
20th and the 18th, the November 20th of 2018, and then December 18th of 2018.
Okay. So why don't you just start making 2 stacks for the gentleman over there for the time being?
I have Exhibit 31 is Stephen Antalix.
Okay.
He's two. Is he two?
And how many dates is he?
He's
Just
only
so
12, 18.
don't make it easy for Mr.
It's 12,
Piper to
18.
cross-check. Just one.
12, 18.
Okay.
He was December 4th, 2018, and then December 18th.
Oh, okay.
Okay.
I missed him.
All right. Yeah, just them for now. The board's going to take, yeah, or you can put one up there. That's fine.
We're gonna give him these back.
What?
Or is he gonna keep?
Craig.
Craig's gonna
Yeah.
keep these.
Mhm.
All right. So let's do this.
31. You'll get a hernia by the time we're done
Did
here.
you want our initials on the front? So
Who's next?
on the front, so we know which ones are.
Barbara Diamond.
Okay. 832. Why don't you?
Attorney Stevens, may I help you?
Yeah. Okay. And how many dates is this one? Can I go by staple? So it's 3, 4?
2018.
There's 4 different packets. Okay.
20th, 2018,
All right. So she was 4.
December 4th of 2018, and December 18th of 2018. All four.
Okay. So all 4. Yeah, we're done with the testimony.
Does Mr. Ronnie will need to stay? Just
I know,
nobody-
and they can
nobody's
go.
gonna testify?
Yeah, 'cause, yeah.
Everybody can go. right?
Yeah. Yeah.
Is that clear?
Yes.
Barbara Diamond was 4. Yeah. 832, but 4.
All right, and then are we ready? Exhibit 33 is Stephen Diamond. And he testified November 8, November 20, December 4th, and December 18th.
Okay, so he's all 4 also.
I'll do the next one then. I won't be available. The next is Cheryl Dugan, and she's exhibit 34, and she just testified on November 20th.
Oh, no, the 9th. I'm sorry, 10-9.
No, I'm on vacation that whole week.
That whole week, right? So 10-9. I'm sorry. I thought it was 10-11.
I think
It's
the
10-9.
other one was October 16th.
So who's that? This is Dugan, and it's just one, right? So Cheryl Dugan. One. Mhm.
The next is Beal Fowler, that's exhibit 35, and he testified November 20th, December 4, and December 18th.
So 3 parts. Okay.
You have copies for the other.
The next is Virginia Fowler. She testified December 4th.
So 836.
Yep.
Okay. Thank you.
The next is Ed Gallagher. He testified November 20th. December 4th, and December 18th.
Okay, so 837, and it's 3 excerpts. That was funny because conversation should be up.
Ready?
Yeah.
Frank Mayberry, and he testified on November 20th.
Is that it? So 8 is Mayberry, and he's 1 excerpt.
Yeah. Next is Karen Beck Pooley, and she's number 39. She testified on November 20th at the hearing.
1 excerpt.
Yeah, and just to add on that one, she also submitted a letter to City Council, and that is in the exhibits. That's Exhibit 14.
Okay.
Next is George Romerl. He's 40. And he testified on December 4th.
All right. So one.
Just that, yeah, just the one.
Okay.
So we're to 41, right? 41.
Mm-hmm.
It's Martin Romerl. And he testified November 20th, December 4th, and December 18th.
All right. 3 nights.
Next is Robert Romerl, and he's Exhibit 42, and he testified December 18, 2018.
One. One stretch.
Oh, he did an extra one for Robert Romerl. If
Yeah.
not,
I didn't make one for Bob.
it's okay. I have it marked. It's just an extra. So then they have two. And 43 is Bill Shire. And he testified November 8th, November 20th, and December 4th.
Oh, so how many was that?
December 4th.
How many total?
3.
Excerpts? 3.
Three.
Okay, sorry.
And the next is Mary Toulouse, and she's number 44. She testified December 18th.
Very Toulouse.
Terry Stevens, are you being paid by the witness or are you being paid by the pound of paper?
844. 844, right? Was Mary Toulouse? Great. Right. Should have 2 left by my count.
This is Ron Yoshida, and he's 45. And he testified on November 20th. And December 18th.
The what? Oh, well, but you made him break it out, so we got to waive the rule. He's allowed to do these without a binder.
And that's it for the deposition testimony. There's also, I mentioned Alan Loucher
Yeah.
and his exhibit, it's exhibit 13 in the exhibit notebook, his letter.
Oh, he's a letter. Okay. All right. So, Mr. Deschler and Mr. Preston, you guys are straight now and got it all? All right. Perfect. And I think the last thing we need to do is get a date. So was it 9 and 16, but 9 now, Mr. Novotny cannot attend. So it'll be the 16th. Is that right?
Assuming that fits everybody's schedule.
Yeah.
16th of
October.
It will not be the regular meeting.
Sorry, what was it?
October 16th.
October what?
16.
I'm attached for a FINRA hearing in Philadelphia on that date. I mean, the cases may settle, but I can't, right now I'm attached.
What does that mean? In terms of,
So you don't think you'd be back in time, or you can't?
Oh, no, it's all day. It's well, I mean, yeah, that's, they go all day and then I'm driving in
Yeah, I know.
Philly, Center City up to here, so.
all right, well,
16th doesn't work.
why don't we go off the record?
Can we adjourn the meeting?
No, because we've got to announce the next date.
Should we just do it here?
Yeah.
About the second.
Let's see. I've got 2 hearings.
Nothing that requires us to do it on a Wednesday if you want
No,
to look at like the
no.
8th.
Terry can't do the 8th. So let's go to that next week. How about 14? Work for you guys?
Of October?
Yeah.
It's the Monday?
It's Columbus Day.
Columbus
so,
Day.
Yeah.
We not have hearings on Columbus Day.
I don't know if City Hall.
You saw how open?
City Hall open?
I don't have it as an official holiday.
Yeah.
It's Thanksgiving in Canada.
I I think we might get some pushback on that just because
Okay.
it's a holiday weekend. You're right. I mean, it's, you know,
I'm kidding. I was kidding.
no, but it's Columbus Day weekend, isn't it?
Yeah, but
It is Columbus Day's on Monday.
Columbus.
Yeah, but it's an official city holiday.
it is?
Is it? I'm not
No,
sure.
I don't think so.
Pardon me? How about the 15th?
I'm good.
Just the 15th works.
15th? So the Timmer, is that just the 16th or you attach? I don't get attached to anything.
Yeah, I'm
but,
attached.
yeah.
I'm attached on the 15th as well.
Wait, is the room, would the room even be available? Because that would be the third Tuesday of the month.
Oh.
That'd be city council
Good
meeting.
point.
Yeah, I'm attached from Tuesday through the rest of that week.
22nd of
So
October.
next
I've
week.
got it. I've got the 21st, 22nd, 23rd of that
Yeah,
week.
that's-
I could do it the
Good the next
24th
week.
It's a Thursday.
of October, or Thursday.
Oh, no, you're good the next week.
October 24.
Wait, isn't that our normal night?
23rd. is your
23rd 's our
regular
third.
meeting.
Right.
24th would be your special meeting. So you go
Okay.
back to back.
Yeah, because I won't be the 23rd. I will have a conflict.
This is the due date. Would be the 25th of September.
So can I- Right, it's just normal stuff, right?
Yeah.
Yeah, so I'll be here on the 24th then.
Yeah.
Okay, all right, that works.
24th.
24th?
Yeah.
All good? All right, so,
Officially, the meeting will be
I
reconvened
don't see.
October 24th at 6 PM in these chambers.
okay,
Assuming they're available, but if they're not, I'll apprise all parties.
okay.
October 24th.
And with that, I think we can adjourn. Officially adjourn.
Yeah, so I don't think I'll